parliamentary sovereignty is followed in UK. Okay, UK doesn't have a written constitution. Hirakud in Sambalpur, I guess. Yes, Sambalpur. You have Satkoshia in Anugul. I hope I'm not getting these places wrong, otherwise लोकों में but since it is written here, the president shall give his assent. That makes our statement here, the president is bound to give assent as a correct statement. Hello everyone, welcome back to our YouTube channel. આજે અમે ଆମ Prelims Pulse Test Series ର first test Polity Sectional Test 1 discuss କରିବା। এই questions रे ମୁଁ ଆପଣଙ୍କୁ କେତେଟା background information, କେତେଟା elimination techniques, some factual information, some conceptual aspects, everything I'll take you through. Then आमे solution भी पढ़िबा just to see आमे जहाँ जहाँ बुझले ठीक बुझले ना नहीं, जहाँ eliminate कले ठीक eliminate कले ना नहीं। Per question I'll try and minimize the time to maybe 2 or 3 minutes. Besi lamba kale again it's going to be unnecessarily long. So stick around, let's learn something new and let's get started with the discussion. So the first question is, which of the following features are common to India and United Kingdom? Why this question? Because India's constitution is heavily derived from the GOI Act of 1935. Although there are aspects from America, from Ireland, from Japan, from Russia, from Canada, but still, jehetu British ruled over us for over 200 years, so their principles are heavily visible in our constitution, in our parliament, and so this question we have made a question on this aspect. Okay, so the first option is आमको जानियार अछि following features are common. Which of the following features are common? सेठी भी अछि, एठी भी अछि. Okay, so এই questions रे not necessary that आपण first एटा पढ़िबे, then एटा पढ़िबे, then एटा पढ़िबे. No, I will say first 8 ही देखंतु and see what you can eliminate first. So मु देखुछि कि एठी 3 multiple times अछि, 4 multiple times अछि. So let me start with 3 and 4. Okay, if I go to fourth statement first, Prime Minister is appointed by the head of the state, and I can instantly say that this is actually correct. Okay, why? Because Sethi, the monarch or the king, appoints the PM. Amaro, we have the president appointing the PM. Okay, they have a constitutional monarchy. We have a republican democracy. So Amaro head of state is president, Tankaro head of state is the monarch, the king, and so even though they are the head of state, the titular head of state, they actually elect the head of the government, the PM. Okay, so this is correct. I have already eliminated A and B. Okay, now 3 is also common in both the options. 8 bhi apan judge karibe. 3 is common in both the options. Permanent upper house to thibo hi thibo. And yes, सेठी bicameral legislature भी अच्छी, सेठी permanent upper house भी अच्छी. Bicameral legislature, तांकर House of Lords and House of Commons. Tankar House of Lords is our Lok Sabha, and Tankar House of Commons, Tankar House of Lords is our Rajya Sabha, and House of Commons is same as our Lok Sabha. So bicameral legislature bhi achi. It is a permanent upper house. It is not subject to dissolution. The lower house रे आमे सब बेले elections करछु 5 years रे, so dissolve होची every 5 years को, और जदि government fall करिगला then before 5 years also, but it is not subject to dissolution, the permanent upper house. So 2, 3, 4 are correct, and hence the answer is C, 2, 3, 4. But that doesn't mean हमें option 1 को ignore कर दबा. Just for some conceptual clarity, let's see what does this mean, parliamentary sovereignty, and why it is a wrong option. See, UK doesn't have a written constitution. I don't know how many of you know this. Written constitution तांकर नाही. तांकर जहाँ भी से माने follow करचुंदी, principles follow करचुंदी, or whatever the constitution they have, the unwritten constitution they have, it is derived from Magna Carta of 1215. फर्स्ट से मैंने अटेम्प्ट करथिले कि हाँ चलो गोटे कोड बनेबा कि किछि रूल्स हबा कथा, लोकंकर राइट्स हबा कथा, एंड ऑल दोज एस्पेक्ट्स. ओके, Then their parliamentary laws, जहाँ भी पार्लियामेंट लॉ बनाए, that in itself becomes, you know, माहेश्मती साम्राज्य की राजमाता इन बाहुबली, मेरा वचन ही है शासन. Okay, so whatever the parliament says, it becomes a law. Okay, then some conventions, then some constitutional expert and their doctrines like AV Dicey. AV Dicey जो rule of law जहाँ भी follow करथिले, जेहेतु तांकर एते भलो थिला, that thought process was good, so they said कि okay एटा को भी हमें follow करिबु. माने it's like saying कि this is a law and this is valid because एटा लक्ष्मीकांत रे लिखा है. See, Lakshmikant is not the source of Indian laws, right? Amara, why this is a wrong option? Because we have constitutional sovereignty, or sorry, constitutional supremacy, not sovereignty, constitutional supremacy. So our parliament, if it makes a law and if it destroys some basic features, or it violates some basic features, the Supreme Court can say कि नहीं तुम एमती करी परिबनी because this is unconstitutional. But in their country, whatever the parliament says, से काली को किछि भी law आन देला, elections हमें करिबुनी, fundamental rights हमें violate करिबु, तांको courts cannot say anything because they have parliamentary sovereignty. So this is the difference between constitutional supremacy and parliamentary sovereignty, and hence this option is incorrect. So this was the first question. Moving on to the next question. With reference to the right to freedom of movement under the Indian Constitution, consider the following statements. Right to freedom of movement is Article 19. The right to move freely throughout the territory of India can be restricted only on the grounds of national security and public order. No, this is not necessary. ये तो अच्छी, but we have general public interest and scheduled tribes, interest of the scheduled tribes. And where is this coming from? This is coming from 1904, okay, where it is written that the right to move freely is can be restricted based on this. So ये only word ta taku bhul kar dochi ये statement ko. Okay, moving on. The right to enter and reside in scheduled tribes may be subject to restrictions to safeguard indigenous communities. Yes, এই সবু concepts jogu we have something called the inner line permit, the ILP, which is followed in the states of Mizoram, Nagaland, Arunachal and Manipur. Okay, माने एठी जदि आपण ट्रैवल करिवे एज अ टूरिस्ट ए सब परमिट्स दरकार बिकॉज ट्राइबल कल्चर को प्रोटेक्ट करिया पे केतेटा प्रोविजंस अछि. ए सब कोड आछी 5th and 6th शेड्यूल रो आछी. ओके, जोटा कि अगेन पार्ट ऑफ द कॉन्स्टिट्यूशन. सो द राइट टू एंटर एंड रिसाइड इन द शेड्यूल्ड ट्राइब्स may be subject to restrictions to safeguard indigenous communities. This is correct. The right to leave the country and return to India is guaranteed under Article 19. No, Article 19 is only dictating the internal movement in India, the internal movement across India. If you leave the country wala part, this is in Article 21. And yara genesis is a very famous case called the Menaka Gandhi case. Okay, Menaka Gandhi's passport was impounded by the government. She was prevented from leaving the country. She appealed this in the Supreme Court, and Supreme Court a case rahi brought the provision called due process of law. Okay, and interpreted it liberally कि इंडिया रे खाली प्रोसीजर एस्टाब्लिश्ड बाय लॉ हमें फॉलो करिबानी, हमें ड्यू प्रोसेस ऑफ लॉ को भी देखिबा, हमें फेयरनेस ऑफ लॉ को भी देखिबा. जस्ट बिकॉज कागज रे लिखा है गवर्नमेंट कैन डू इट डजंट मीन गवर्नमेंट कैन डू इट. इफ द गवर्नमेंट इज डूइंग इट, इज इट रेस्पेक्टिंग द राइट्स ऑफ पीपल, एटा भी हमें देखिबा. सो हमें ड्यू प्रोसेस ऑफ लॉ ए जो केस रे आस्थिला, एंड दिस इज वेयर सुप्रीम कोर्ट सेड कि the right to leave the country and return to India is a fundamental right under Article 21 and not Article 19. So this statement is also incorrect. So how many of the above statements are correct? Only 2 is correct, and hence the answer is only 1, because the question is how many are correct, not which of the above is correct. Only 2 statements are wrong, only 1 is correct, and so the answer is only 1. Okay, moving on to the next question. The Supreme Court at Calcutta was established by, very easy question, the Regulating Act of 1773. Lord Warren Hastings, the first Governor General of Bengal, CAE Act आनिथिले, Supreme Court established kale at Calcutta, and the first Chief Justice was this person called Elijah MP. Okay. से जो बैटल ऑफ बक्सर पर जो जिते ब्रिटिश टिके सुप्रीम पोजिशन को आसला 1765 रे तापरे मद्रास रे एंग्लो not Madras, sorry, Mysore, Anglo-Mysore wars chalthila. It was during this time that they decided that एमती अलगा अलगा प्रेसिडेंसीज रहिले आमे केबे कोऑर्डिनेट करि परियानी. We need people so that we need to have a governance structure where each presidency is somehow connected to each other, and we need laws for that. So they brought this regulating act. Provisions you can read them. Maybe if I go to the details of all the provisions, then unnecessarily lamba video hijibo. But yeah, this question is Regulating Act of 1773. Okay, remember this name, Elijah MP, the first Chief Justice of the Supreme Court at Calcutta. Okay, moving on to the next question. Which of the following are federal features of the Indian Constitution? So federal features, federalism, simple terms re, there have to be multiple, and by multiple I mean at least 2 levels of government. Okay, central level government and a state level government. Okay, central and state. So and India is known as a quasi federal system. Okay, not officially, officially we are a federal nation, but experts have deemed that us as quasi federal nation because we are half federal, half unitary, or more unitary, less federal. Okay, and से यही हमको इठी identify करियार अछि कि which of the following are federal features. Okay, let's see. Written constitution. Why written constitution is a federal feature? Because once it is written down in the constitution, it is not easy for the central government or the parliament to change it, to repeal it, to amend it. Okay, it is not that easy. So once it is written down in a constitution that that there are several federal features, so parliament cannot take it away, and hence India's federal structure can be safeguarded. So this is a federal feature. Jodi unwritten constitution habo, jemti UK re hochi, तो ସେମାନେ କ'ଣ କରିବେ, ପାର୍ଲିଆମେଣ୍ଟ ଖାଲି କହିବ କି ନାଇଁ କାଲିଠୁ ଷ୍ଟେଟ୍ ଗଭର୍ଣ୍ଣମେଣ୍ଟସ୍ ବଗେରା କିଛି ଏକ୍ଜିଷ୍ଟ କରିବନି, ଆମେ ଏଥର ୱାନ୍ ସେଣ୍ଟ୍ରାଲ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ରହିବ ଯିଏକି ଚାରିଆଡ଼େ ଯାଇକି ଗଭର୍ଣ୍ଣ କରିବ ଆଣ୍ଡ ଚାରିଆଡ଼େ ତାଙ୍କ ଏଜେଣ୍ଟସ୍ ଥ୍ରୁ ତାଙ୍କର ଗଭର୍ଣ୍ଣାନ୍ସ ଚାଲିବ. ସେଠି କେହି କିଛି କହିପାରିବେନି ଇଫ୍ ଇଟ୍ ଇଜ୍ ଅନରିଟନ୍. ବଟ୍ ରିଟର୍ନରେ ଯଦି ଏମିତି ପାର୍ଲିଆମେଣ୍ଟ କିଛି କରିବାକୁ ଚେଷ୍ଟା କଲା ତାହେଲେ ସୁପ୍ରିମକୋର୍ଟ କହିପାରିବ କି ନୋ ଦିସ୍ ଇଜ୍ ଅନକନଷ୍ଟିଟ୍ୟୁସନାଲ, you have to respect the federal structure of India. Okay, so that is why written constitution is a federal feature. Now moving on, all India services. Now this is a unitary feature. Kahinki karan center ro loko chariade jainki basuchanti and eventually center ro policies ko encourage କରିବାକୁ ଚେଷ୍ଟା କରୁଛନ୍ତି, ସେଣ୍ଟରର ପଲିସିଜକୁ ଏକ୍ଜିକ୍ୟୁଟ୍ କରୁଛନ୍ତି. ଓକେ, ତ ଯଦି ଷ୍ଟେଟ୍ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କିଛି କରିବାକୁ ବି ଚାହୁଁଛି, ଯଦି ସେଣ୍ଟ୍ରାଲ ଲୋକ ଆସିକି ତାକୁ ମନା କରିଦେଲା ଯେ ଆଇଏଏସ୍ ବସିଛି, ଯେ ଆଇଏଫଏସ୍ ବସିଛି, ଯେ ଆଇପିଏସ୍ ବସିଛି, ଯଦି ସେମାନେ ତାଙ୍କ ହିସାବରେ ଦେଖିଲେ କି ଦିସ୍ ଇଜ୍ somehow not according to what the central government wants, then they can not allow it. Okay, so all India services is a unitary feature. Bicameralism, yes, राज्य सभा रे ये सब स्टेट्स रो जो सब जाइंके रिप्रेजेंटेटिव्स बसंती से निज स्टेट्स रो इंटरेस्ट पई ही जाइंके सेठी बसे थांती, राइट. So this is a federal feature because state ro interests are being taken care of. Okay, supremacy of the constitution, again yes, ठीक written constitution जेमती सेमती supremacy of the constitution is also the same thing. जदि एथि supremacy of the parliament थांता then सेटा गोटे wrong option ही थांता, but supremacy constitution अच्छी बोली फेडरल फीचर्स को आम सेफगार्ड करि पारछे. जदि कॉन्स्टिट्यूशन न थांता, जदि सुप्रीमेसी ऑफ द कॉन्स्टिट्यूशन न थांता, देन फेडरल फीचर्स को आम सेफगार्ड करि पार न थांते. सो सही कॉन्सेप्चुअली जदि टिके बुझिबे देन इट इज इजी. ओके, सिंगल कॉन्स्टिट्यूशन. नो दिस इज अगेन अ यूनिटरी फीचर. US रे you have two constitutions. One is the national constitution, the federal constitution, and each state has its own constitution. Okay, So this state having its own constitution is a true federal feature. Okay, but only a single constitution governing all the um, aspects of a country is actually a unitary feature. So this is unitary, this is unitary, this is federal, this is federal, and this is federal. So we have three options that are federal. Select the correct answer using the code. Only two options are correct, only three options are correct. The answer is B. And if we see some other aspects of this, what are the other features? Let's just read through it once. In a federation system, there are two seats of power that are autonomous in their own spheres. Federal system is different from unitary system in that sovereignty is constitutionally split between two territorial levels so that each level can act independently of each other. India रे कौन अच्छी federal features of Indian constitution? So ए तीनटा हमें देखिले. ता छड़ा you have dual polity, division of powers, the seventh schedule जो ठीक ही you have the union list, the state list, and the concurrent list. Okay, so since state list is there are some subjects joti only states can make laws on. Hence, this is a federal feature. Okay, division of powers. Supremacy of the constitution, like I said, helps negate any attempts at violating federal aspects of the country. Okay, rigid constitution, this is also important. Now why is rigid constitution important? Because जदि rigid constitution न हेथांता, जदि बहुत ही flexible constitution हेथांता, ताले तो unilaterally खाली parliament ताको amend करिकी again सब जगह powers central government निज पाखु नहीं जानता. But this is not possible in India. Yes, most aspects can be amended by parliament, but there are certain features जोठी की states रो ratification भी दरकार. Hence, this is a rigid constitution because you need ratification of states in several features, federal features especially. Hence, this is the correct option. And a correct feature. Independent judiciary. Yes, this is also important. Like I said, any attempts by parliament have to be negated by the judiciary. Jodi judiciary independent no thanta, committed thanta, government ro stooge thanta, government ro kotha man thanta. ताले again that wouldn't have been a federal feature. से तो जहाँ government को कोई था से आई से मानी जानते. Hence, independent judiciary is important. And bicameralism, like I said, राज्य सभा लोक सभा राज्य सभा रे सब states रो लोग जाएंगे बसंती तांको states रो interest fulfill हो सेथिपाई. And hence this is a federal feature. Okay. Conceptually टिके clear रहिबे. Which of the following is not correct with reference to provisions mentioned in the preamble of the Indian Constitution? You'll see, okay, equality of status and opportunity. Yes, mentioned. Preamble includes liberty of thought, expression, belief, faith, and worship among its core ideals. Yes, mentioned. Question is not correct. एटा बहुत लोग भूल करती. Question not correct देखते नहीं, correct मार दे पड़े आसंती या correct पचारती वो incorrect मार दे पड़े आसीबे, incorrect पचारती वो correct मार दे पड़े आसीबे. टिके ता विषय अपन सब बेले careful रहिबे. Equality before law and equal protection of law are explicitly mentioned in the preamble. No, this is not a preamble. This is Article 14. आपको लागू एते easy questions kind devise करछंती. This was the first test where we are trying to test the fundamentals. Hence, the questions might seem easy, but as the test progress, as you gather, as you grasp more and more concepts and knowledge, सेमती questions papers level भी टिके difficult यही चलिबो. But yeah, these are some easy questions that we have devised so that you are eased into the process. Okay, so yeah, this is Article 14, which is a fundamental right. This is not mentioned in the preamble. Preamble को घोषि देथिबे. Preamble घोषिबा बहुत important because गोटे गोटे कीवर्ड उपरे गोटे गोटे क्वेश्चन बने कि से माने आपन कंफ्यूज करिया चेष्टा करि परिबे. ठीक अछि. What was the constitutional status of India on 26th January 1950? See, so again, it is factual knowledge दरकार. Secular socialist ए दिटा ऑप्शन काई हबनी because ए दिटा 42nd amendment रे आस्थिला 1976 रे. ओके, तो ए दिटा ऑप्शन हे परिबनी. तो अ डेमोक्रेटिक रिपब्लिक और अ सोवरेन डेमोक्रेटिक रिपब्लिक एटा अगेन कोट लिखा है प्रिएम्बल लिखा है sovereign democratic republic. Okay, and later secular and socialist were added to the preamble. But question is 26th January 1950 रे कौन status थिला? So the answer is sovereign democratic republic. मु सॉल्यूशंस गुड़ा भी आपन को देखे एक्चुअली भूली जाउची बट सॉल्यूशंस रे से आई मुझे कहूची से आई लिखाई छी एठी लाइक आई सेड options A and C are correct. Why? Equality of status and opportunity. Yes, it is mentioned. Liberty of thought, expression, belief, faith mentioned. Equality before law, equal protection of law are part of Article 14. ठीक है. Then on 26 January 1950, when Constitution of India came into force, India was declared a sovereign democratic republic. Socialist and secular were added through 42nd Amendment Act 1976. Okay. And यार किसी किसी technical meaning अच्छी, you can pause the screen and read, or if you are a part of our test series, this was actually an open test जार की solution हम telegram channel रे अच्छी, तो you can go and download it from there and read the solutions. Okay, with reference to article 15 and 16, okay, this is an interesting question, ଆଉ ଟିକେ knowledge दरकार. Article 15 was amended by the 93rd Constitutional Amendment to allow reservations in private unaided educational institutions. See, ya purburu there were two cases, TM Pai and Inamdar. Okay, two cases. ए केसेस रे सुप्रीम कोर्ट कहिथिला कि रिजर्वेशन रो कांसेप्ट तमे प्राइवेट कोर्ट रे प्राइवेट एजुकेशनल इंस्टीट्यूशंस रे आनी पारिबो नाही. ठीक अछि. So to negate that, government brought the 93rd Constitutional Amendment to allow reservations in private unaided educational institutions. This is correct. এটা আজি পর্যন্ত भी होची. आपन जदि मूवीटा देखिचंती हिचकी, ओके, the whole premise of that movie is गोटे बहुत बॉलर reputed school रे गोटे slum रो पिला माननकु admission दिया होची, and how those slum people are also are first, underestimated by the so-called classy students, so-called elite students, but eventually they also showcase their capability and say their messages. If given the opportunity, every child can excel. Okay, so हिचकी जदि देखिबे, you will find out that this is the whole premise. Reservations in private unaided educational institution. Even Irfan Khan ra movie English medium, I guess, English medium, where he has to act as a poor person to get his child admitted in a very top Delhi school. Okay, so these two movies will tell you the background movie story of this whole article, article 15. This is article, okay. Then article 16 permits the state to make special provision for the advancement of any socially educationally backward class, including in private employment. No, although education private institutions रे reservation अच्छी, but private employment रे मुझे Accenture को या फिर Infosys को कही परिबिनी कि तमे reservations रखो for on the basis of caste आंको 80% चाकरी दबा पाए. No, that is not allowed in our constitution. This statement is wrong. Okay, in fact एई सबु जिनसोई हरियाणा एबे गोटे बिल आनिथिला कि reservation 80% रहिबो for people of Haryana in private institutions, जोटा कि अगेन वेरी controversial. More and more states are trying to do this. Okay, किछि ना किछि गोटे, because these interpretations are so so subjective, so they are trying to say कि आमे employment आनिया पे एटा करिया को आमे एटा करि पारिबा, constitutionally allowed अछि. Supreme Court is looking into all these aspects. Okay, so but it does not permit blanket permission नाही. जदि किसी तोड़ बाहर करिकी भल भल लॉयर्स को धरिकी कॉन्स्टिट्यूशनल इंटरप्रिटेशन को धरिकी आपण जदि जस्टिफाई करि पारछंती ताले सुप्रीम कोर्ट अलाउ भी कर दे पारे, बट एज सच एटा nahi. Okay, this is correct, this is wrong. Already we know since 2 is wrong, answer is 1 and 3. So 3 must be correct, but let's see what is 3. Article 15(6) inserted by the 103rd Constitutional Amendment enables reservation for EWS in educational institutions, excluding minority institutions. This is correct. This has been a subject of much debate. এই ସବୁ लूप होल्स यूज करिकी ही so many IAS officers are getting into the services, but later जଣା पड़ुची कि तांको EWS सर्टिफिकेट से माने कोटा कोटी लूप होल्स यूज करिकी बनेइछंती, करप्शन करिकी बनेइछंती, एंड देन से माने परे धरा पड़ुचंती. एबे बहुत सारा ऑफिसर्स अंडर इन्वेस्टिगेशन भी अछंती. So you should know that this was actually the 103rd amendment. And if we go to the solution of this one, yeah, 93rd Constitutional Amendment Act, enabling the state to make special provisions for SCs and STs in admissions to educational institutions. This is correct. Statement 2 is incorrect. Article 16 pertains to equality of opportunity in public employment and allows for reservations. for backward classes in public services. However, it does not extend to private employment. And the 103rd Constitution Amendment Act, 10% reservation for EWS, but excludes minority under Article 30. Minority institutions रे EWS ର କିଛି ମାନେ ଇଏଗୁଡ଼ା ଲାଗୁ ହବନି. Okay. So this was about Article 15 and 16. According to the Constitution of India, a state assembly can do which of the following? This is straight lifted from Article 3, all the options. All of them are correct. And it a hubahu Article 3 re lekha hai. Parliament may by law form a new state, increase the area, diminish the area, alter the boundary, alter the name. Parliament पाखे ये सब powers अच्छी to ये सब powers Parliament को दिया है ची to preserve the territorial integrity of India. जदि ये सब states पाखे थांता then झगड़ा करे कि बहुत जल्दी इंडिया disintegrate ही जाए थांता. But this is a power that has been so if we go back to that federal wala concept, this is actually a unitary power. Okay, this is not a federal feature. Federal feature would have been giving those states permission to leave India if they wanted to. जोटा कि US रे अच्छी. Those states can leave the US if they want to. Okay. So that is why it is the United States of America. All the states have come together voluntarily to form the country, but they can also leave voluntarily. It's not that easy, but they can. Okay. So this is a unitary power that has been given to the parliament to safeguard the territorial integrity of India. When we started, we were more than 500 states. So they thought कि जदि एमती आमे powers दे देले तेने माने निजो को बड़ा पेटे पेटी ही खाइजिबे मार देबे. तो ସେଇଥିପାଇଁ ଆଇରନ୍ ମ୍ୟାନ୍ ସର୍ଦ୍ଦାର ବଲ୍ଲଭ ଭାଇ ପଟେଲକୁ କହିବାରୁ ଏଇ ସବୁ ପ୍ରୋଭିଜନ୍ସ ରଖାଯାଇଛି ପାର୍ଲିଆମେଣ୍ଟ ପାଖରେ. which is why you have Telangana, Jharkhand and Uttarakhand and all these states that have been carved apart from Andhra Pradesh, Bihar, Uttar Pradesh, etc. Okay. Yeah. How many times has the preamble been amended? Oh, this is a factual question that OPSC is fully capable of asking, just to confuse you. The answer is once. Same. 42nd, 1976. The socialist, secular and addition of the words socialist, secular and integrity in the preamble. तापरे केबेठु आमे preamble को amend करिने. That remains the only amendment. Okay. With reference to key legislations during British rule in India, consider the following statements. So এই সব Charter Acts বিষয়ে এইটি পচরা হচ্ছে. Charter Act of 1813 ended the East India Company's commercial functions and introduced open competition for civil services. No. See, half is correct, half is wrong. Introduced open competition for civil services is Charter Act of 1833. ठीक है. This is Charter Act of 1833. And ended the commercial functions. Yes, ended the commercial functions except for, can you tell me? Except for tea and trade with China. Okay. बहुत पैसा तांको मिलुथिला एथरु जा जगु के टैक्सेस बहुत बढ़िया से माने पे करूथिले, रॉयल्टी बहुत बढ़िया पे करूथिले बैक टू द गवर्नमेंट. सो तांको गवर्नमेंट छूट देला कि ठीक अछि टी रो व्यापार तमे करो चाइना संगे, वी वांट hamper your activities, but other than that all your commercial activities will now be ended. This is Charter Act of 1813. But since second half is wrong, so this is a wrong statement. So 1 and 2, 1 and 3 এই जो দুইটা statement already eliminate হয়ে গেলা. এইটু আমি জানলে যে 4 is somehow correct, has to be correct. Now we have to decide between 2 and 3. তো আগে 4 দেখ দাও. Under the Pitt's India Act of 1784, the company's territories in India were officially termed as British possessions. Yes, दिया है ची बहिरे. Okay. But now 2 and 3 रे कोडा ठीक. Let's decide. चलो. The Government of India Act 1858 formally dissolved the East Indian Company and vested all administrative powers directly in the British Crown. This one is the correct option. After the 1857 war, so 1857 war रे से मानको बहुत बड़ा झटका लागेला. ओके कि एमती केमती से मैंने यूनाइट है कि आम अगेंस्ट एते बड़ो वॉर, एते बड़ो स्केल रे वॉर गोटे दे वर एबल टू रेज अ वॉर. सो दे सेड कि मिसगवर्नेंस तमे बहुत मिसगवर्न करछो ए एरिया को आउ तमे करबनी. ओके. सो दे अपॉइंटेड अ secretary of state. The British crown personally, India became a part of the British crown. A secretary of state was appointed. This was an officer of the British cabinet. ब्रिटिश कैबिनेट रो गोटे मेंबर थिला ये ठीक अच्छे सेक्रेटरी ऑफ स्टेट अपॉइंट हैला ब्रिटिश कैबिनेट अपॉइंट हैला ब्रिटिश कैबिनेट मेंबर थिला लॉर्ड कैनिंग became the first viceroy of India. Okay, the representative of the British Crown, formal representative of the British Crown of India, Lord Canning, remember. So 1858 formally dissolved the East India Company and vested all administrative powers directly in the British Crown. Okay, and so this is, since this is correct, so our answer is 2 and 4, but let's see why 3 is incorrect. 3 रे दिया हेची the Charter Act of 1833 was the last act to retain the company's rule in India. No, 1833 रे again 20 years ପାଇଁ ବଢ଼ା ହେଇଥିଲା and 1853 was the last act. Charter Act of 1853 was the last act where company's rule was retained indefinitely. ମାନେ ସେମାନେ ଏମିତି 13 ରେ ଆସିଲା ଯେତେବେଳେ ସେ କହିଥିଲେ 20 ବର୍ଷ ଆଉ ବଢ଼ା ହେବ 33 ରେ ଆସିଲା ପୁଣି ଆଉ 20 ବର୍ଷ ବଢ଼େଇଲେ ବଟ୍ 53 ରେ କହିଲେ କି ନାଇଁ ଆମେ indefinitely ବଢ଼ଉଛୁ and eventually after 5 years they brought this act where Companies Act was totally abolished, totally ended and India became a part of the British Crown. Okay, so the answer is 2 and 4. ठीक है ये सब chronology जेहेतु इतने सारा facts अच्छी starting from regulating act of 1774 to Pitt's India Act of 1784, regulating Act of 1793, 1813, 1833, 1853, 1858. Then tapare India Councils Acts ଆସିଯିବ 1862, 1891, and then Montagu Chelmsford reforms ଆସିବ 1935 Act ଆସିବ ये ସବୁ ଜିନିଷ ବହୁତ minute details ଅଛନ୍ତି so you have to learn them very carefully ମନେ ରଖିବାକୁ ପଡ଼ିବ picture ବନେଇବାକୁ ପଡ଼ିବ story ବନେଇବାକୁ ପଡ଼ିବ only then you will be clear with all these aspects. Okay, which of the following is not explicitly mentioned in the UDHR? See, this is a very often asked question. wo jo last video achi moro prelims preparation ro you can see there 3-4 thara over the years they have asked direct questions from UDHR re co article co right achi nahi etc etc. So let me tell you UDHR is a list of 30 rights, 30 fundamental rights, and UDHR has been given by UNGA resolution number 217. Okay, ये सब factual aspects important, keep noting them down. 1948. So if you read the options, seek asylum from persecution, yes it is mentioned. Right to nationality, mentioned. Participate in cultural life, mentioned. Right to bear arms for self-defense. Now this is a right in US in many states. Okay, but this is not mentioned in the UDHR. UDHR एमती किसी mentioned nahi. So the answer here is D. Okay, this is Article 14, this is Article 15, and this is Article 27 of the UDHR, but this is not mentioned in the UDHR. So I would advise you कि what you can do, Article 1 to 30 से rights कुड़ा list. Okay, you can have a look because they can ask Article 15 of UDHR कौन कोची, they have asked, they can ask again. And तागुडी relate करिबे Indian Constitution सांगरे. So Article 2 of UDHR is related to what feature of Indian Constitution. Okay, ताकु जो relate करी पढ़िबे आउरी भल से मन रहबो. ठीक अछि. Which significant reform did the Indian Councils Act of 1892 introduce for the first time? ठीक अछि. It established new legislative council for Punjab and Bengal. No, this came much later. Introduced separate electorates for different religious communities. No, this came in 1908. It granted full legislative autonomy to princes. Not a chance because 1892 रे एते सारा माने 1935 पर्यंत भी जेतेले autonomy दिया है नहीं 1892 रे कोठु आसला. Then the answer is it allowed the indirect use of elections in fulfilling non-official seats in legislative councils. So yeah, this is माने एबे आकु कनेक्ट केमती करिवे ए जिंसटा को मने केमती रखिबे ते एते बेलू को कांग्रेस आसी गलानी 1885 रे कांग्रेस आसी गलानी मॉडरेट्स आसी गलेनी and moderates रो गोटे डिमांड थिला constitutional reforms. They believed in the inherent goodness of the British government but they had a demand of constitutional reforms and since they were loyal to the British government so British government गोटे एमती photo just गोटे कैजुअल गोटे दे देला कि हाँ ठीक है चाहो तुम इतना लॉयल्टी दिखाया तो हम भी खुश हुआ लो ये लो एक प्रोविजन. वो प्रोविजन क्या था? Indirect use of elections in filling non-official seats in legislative councils. ये जो एते बेल जाए सब जगह माने ये members थिले British members थिले इंडियंस को भी एथर अलाउ करा है, एजुकेटेड इंडियंस को, एलिट इंडियंस को फ्रॉम द म्युनिसिपालिटीज, द डिस्ट्रिक्ट बोर्ड्स, ओके, द कॉमर्स चेम्बर्स, ये सब एरिया रे जहाँ सब इंडियंस मैंने थे तांको भितरु हाँ तुम अपने आप में डिसाइड कर लो कि कौन आके ये नॉन ऑफिशियल सीट्स को भरना चाहता है। तो तांको भितरु एमती इलेक्शन, तो एठी आम कंट्री रे इलेक्शंस रो प्रिंसिपल टा फर्स्ट टाइम यूज हैला। ओके, एतबेले जाए सब जहाँ गवर्नर जनरल वाइस रॉय जहाँ कहते से माने ही आसिक बसुले काउंसिल रे, बट एटी गोटे गोटे प्रिंसिपल इन प्रिंसिपल इलेक्शंस वेर इंट्रोड्यूस्ड हियर, सो दैट इज व्हाई आल्सो council act of 1892 is important। okay, that takes care of this question। yeah, so if I can give you some more information, why I am saying this was a very casual introduction, because these members were not allowed to ask supplementary question। okay, कि अगर कुछ गवर्नमेंट ने कुछ अगर प्रोविजन लाया, सो दे वर नॉट अलाउड टू आस्क सप्लीमेंट्री क्वेश्चंस कि ऐसा क्यों है, ऐसा क्या है, कि सर चलिए हम डिबेट करते हैं कि ये नहीं होना चाहिए, नहीं, दे वर जस्ट सिटिंग देयर, अटेंडेंस पकया पे, प्रेजेंट सर कया पे, एंड देन दे वर लेट गो। ओके, दे वर नॉट अलाउड टू वोट ऑन द बजेटरी प्रोसेस, जो बजेट पास होता एमानकर किसी पावर्स नथिला वोट करिया पे। सो अगेन खाली अटेंडेंस पकया पे थिले, बट या एमती सब किसी तो एकाथरे होनी, ग्रेजुअली हम। तो दिस वाज द फर्स्ट बिगिनिंग वेयर किसी गोटे देखागला कि हाँ ठीक अच्छे, इंडिया इज मूविंग टुवर्ड्स सम सॉर्ट ऑफ गेटिंग सम सॉर्ट ऑफ स्वराज पर से टेक्निकली। ओके, so that was that। Consider the following provisions: establishment of an all India federation, कौन question कौन सी, which of the above were embodied in the Government of India Act 1935, एटा the question। establishment of an all India federation, introduction of provincial autonomy with a government responsible to an elected legislature। so this is correct, yes। ସେମାନେ ଗୋଟେ ଏମିତି ଚେଷ୍ଟା କରିଥିଲେ ଫେଡରାଲ ଅଲ୍ ଇଣ୍ଡିଆ ଫେଡେରେସନ୍ ଆଣିବା ପାଇଁ, but it failed, it never came into fruition। why? because यार ଗୋଟେ कंडीशन थिला कि a minimum number of princely states must sign this। okay, but that never happened, princely states did not sign it, and hence an all India federation wasn't formed। but wasn't formed doesn't mean it was not embodied, it was embodied, and question seya pacharchi, so one is actually correct, it just never happened। एमती गोटे मु लॉ आनी थी कि एमती आमे करिबा, बट सेटा केबे हेलानी, दैट डजंट मीन लॉ रे एटा लिखा है नथिला। ओके, तो कंफ्यूज हेबेनी। देन इंट्रोडक्शन ऑफ प्रोविंशियल ऑटोनॉमी विथ अ गवर्नमेंट रेस्पॉन्सिबल टू एन इलेक्टेड लेजिस्लेचर, नो, द गवर्नमेंट वाज नेवर रेस्पॉन्सिबल। गवर्नमेंट रेस्पॉन्सिबल होते परे जो एते सारा कंडोल है, राडा है, एंड ऑल दोज थिंग्स केबे हे न था। गवर्नमेंट वाज स्टिल कंट्रोल्ड लार्जली बाय द governor general, the viceroy। so this never happened, so this statement is incorrect। the answer here is one only। just out tikke details jodi if I can give you, the Government of India Act 1935 proposed the establishment of All India Federation। it was intended to include both in British Indian provinces and princely states. However, its implementation was conditional on a required number of princely states agreeing to join, which never happened। So this is what I said, this is why statement 1 is correct, but statement 2 kahin ki bhool। Although the act introduced provincial autonomy, it did not establish a fully responsible government at the federal level। the administration was divided into reserved and transferred subjects। it reserved and transferred, if you can recollect, there was something called diarchy। okay, then 1919 act re, Government of India Act 1919 re, they had introduced diarchy at the provinces, ठीक है, but that didn't work, so they abolished this, and in the 1935 act they introduced diarchy at the center। what was diarchy? Diarchy re, there were two lists, a transferred list, a reserved list। okay, transferred list re सब छोट मोट जहाँ भी जिनस अकॉर्डिंग टू दैट टाइम, एजुकेशन, हेल्थ, लोकल गवर्नेंस एंड ऑल दोज एस्पेक्ट्स कि जाओ काउंसिल को दिया है कि जाओ ठीक अच्छे पावर तुम पाखे रहा, वोट करो, लॉज बनाओ, जाओ जहाँ भी सेठी जो स्टेट लेजिस्लेटिव काउंसिल जहाँ भी थिला। बट दिस रिजर्व्ड एटा निज पई रिजर्व करके रखुले किए, द गवर्नर जनरल। ओके, सीए निज पई foreign affairs, communication, डिफेन्स ऑल दिस इंपोर्टेंट एस्पेक्ट सेटा निज हाथ रखुले से जहाँ कहे से हम एथरे लेजिस्लेटिव काउंसिल लेजिस्लेटिव असेंबली किसी रोल नहीं. So to say that it was a fully responsible government at the federal level is technically incorrect, and hence the answer is 1 only. Okay. Next question. Other than the fundamental rights, which of the following parts of Indian Constitution reflects the principles and provisions of the UDHR 1948? Okay. So generally a sub questions or answers is D, in general. Why? Because each right can be interpreted in so many ways that kichi na kichi connection bahari jibo with preamble, with DPSP, with fundamental duties. Okay, ketela UPSC ro bhi questions ase. The onus here is on the examiner to prove कि एटा नुहे, बट 99% ऑफ द चांसेस आपण पाखे अच्छी कि प्रूफ करदेवि जे हाँ दिस UDHR ए प्रोविजन is related to fundamental duties रो ए प्रोविजन. ओके, ये जो सब क्वेश्चंस आसे यूपीएससी रे, which of the following are primary pollutants of pollutant sources of say sulfur dioxide. सो से जहाँ 5-6 ये थिबो तो इट्स वेरी डिफिकल्ट टू प्रूव कि एई थ्रू गोटे भी ऑप्शन रु 1% भी SO2 बाहर नथुबो. ओके, हेंस द आंसर इन जनरल इज ऑल ऑफ द अबव. ठीक सेमती एटा भी गोटे से भलिया क्वेश्चन. ओके, इन जनरल दिस इज 1 2 3. एंड इफ आई गो टू द डिटेल्स, सी प्रिएम्बल रे जहाँ भी सब लिखा है इक्वालिटी टर्म इज मेंशन, डिग्निटी टर्म इज मेंशन, एंड आर्टिकल 1 ऑफ UDHR इज एक्चुअली डिग्निटी इन लाइफ ऑफ पीपल. ओके, एमती आपण रिलेट करि परिबे. आर्टिकल 22 ऑफ UDHR सेज सोशल सिक्योरिटी. ठीक सेमती आमर आर्टिकल 41 सेज एड फॉर वर्कर. ओके, ये जो सोशल सिक्योरिटी तो ये दुटा को रिलेट करी हला. फंडामेंटल ड्यूटीज रे UDHR रो आर्टिकल 29 कोची, यस UDHR रो आर्टिकल 29 कोची ड्यूटी टुवर्ड्स कम्युनिटी. ठीक अछि, एंड आम फंडामेंटल ड्यूटीज भी से कहते brotherhood, women, animal, environment, all those aspects. So we can relate UDHR to each of these aspects, and hence the answer is 1 2 and 3. Okay, then the next question, the motto yato dharmas tato jaya has been adopted by which of the following? MTF factual question, बिल्कुल पचारि पारिबो OPSC, which is famous for asking such vague questions. The answer is Supreme Court. very factual. एथरे किछि जानियार नाही, खाली देखि दियंतु, पिक्चरटा देखिदेले मन रहिजिवो. यतो धर्मस्ततो जया is a Sanskrit expression meaning where there is dharma or righteousness, there is victory. It is a motto by the Supreme Court of India and is inscribed below the national emblem in its official seal. Okay, आपको खाली देखिदेले once you will be able to recollect कि okay एमती किछि गोटे मु पढिथिली. देखिए एटा के क्लियर कर दवा. Yeah. Now, next question is, consider the following statements regarding composition of the Constituent Assembly. This is a purely factual question. एथरे किछि concepts नहीं, so we'll just move to the solutions very quickly. M.N. Roy was the only member representing the Communist Party of India in the Constituent Assembly. This is incorrect. Communist Party of India had zero representation in the Constituent Assembly. There was not a single member from CPI who was present in the Constituent Assembly. A factual information. B.N. Rao was appointed as the constitutional advisor to the Constituent Assembly. Correct. Again factual. Muslim League members elected from the Indian Dominion gave up their membership in the Constituent Assembly after partition. Yes, this also happened. They went to Pakistan, so they had to give up their membership. And Rajendra Prasad was elected as the temporary president of the Constituent Assembly in the December 1946. No, this is wrong. This was Sachidananda Sinha. He was elected as the temporary president, and eventually Rajendra Prasad was elected as the permanent president. So this is right, this is right. The answer is 2 and 3. Okay. If I am missing out on something, let me just check. M.N. Roy, Communist Party did not have formal representation. B.N. Rao was appointed as A, correct. After partition, Muslim League went back. Rajendra Prasad was elected as permanent president on December 11, 1946, while Sachidananda Sinha served as temporary president on December 9, 1946. The dates could have become important because OPSC tends to ask dates. Okay. Which of the following statements is correct regarding cultural and educational rights? Article 30 provides the right to establish and administer educational institutions only to religious minorities. No. Article 30 रे clearly लिखा है religious and linguistic both. It's not only. ठीक ଅଛି? This statement is correct. This statement is wrong. आमको पचरा है वो कोटा correct हबो. Okay, चलो देखिबा. Article 29(2) prevents the state from denying admission to any citizen in an educational institution solely on the grounds of language, caste or religion. This is actually correct. Okay. लिखा ही है constitution रे. Minority institutions under Article 30 are bound by the same rules regarding reservation as state-run institutions. एबे ही आमे पढ़िले कि TM Pai and Inamdar case परे ए जो सब reservations आसिला excluding minority institutions. एमती बहुत थोड़ा OPSC पेपर रे भी हुए. गोटे क्वेश्चन रो ऑप्शंस इज बेसिकली आउ गोटे क्वेश्चन रो आंसर. से माने एटा भी चेक करियो देखंती कि प्रेजेंस ऑफ माइंड केते अछि पिलार. ठीक अछि. तो जदी एठो आपण एटा देख दोचंती देन यू विल एबल टू eliminate this one ki minority institutions are not subject to the same rules as reservation. Okay, so this is also wrong. The first one is wrong. Article 30 guarantees state funding for all minority institutions. No. Article 30 prevents discrimination. Okay. While allocating funds. Government cannot say कि मु ए religious denomination को देबी एतिकी पैसा ए religious denomination को देबी एतिकी पैसा. एमतिया से माने discriminate करि परिबेनी. But that doesn't mean कि there is a guarantee कि this will get funding from the government. No. So it prevents discrimination, but there is no guarantee. Okay. Yeah. So this is about this question. This is the correct option. Article 29B prevents the state from denying any citizen solely on the grounds of language, caste or religion. Okay. Now, stay just a minute. Yeah. Some fundamental rights can be claimed by Indian citizens only. Yes. 15, 16, 19, 29, 30. This is Indian citizens only. This is correct. Both the basic. All fundamental rights are enforceable against the state. Of course, this is correct. So just to ଟିକେ confusion ये करिया ପାଇଁ ଏଟା ମୁଁ Telegram channel ରେ ଥରେ ପଚାରିଥିଲି and many of them actually got this wrong. Of course, fundamental rights ଆମେ enforce government against रे तो करूचे, state against रे तो करूचे. Okay. ଯଦି ଏଇଠି ଥାନ୍ତା all fundamental rights are enforceable against private individuals ତାହାଲେ ଏଇଟା ଭୁଲ ହେଇଥାନ୍ତା. Okay. ତାହାଲେ ଏଇଟା ଭୁଲ ହେଇଥାନ୍ତା. But ଯେନ୍ state ଅଛି ତ state against ରେ ତ ଅଛି ହିଁ ଅଛି. But କେତେଟା private against ରେ भी ଅଛି. So this statement is correct. This statement is correct. The answer is both 1 and 2. Yes, Article 15, 16, 19, 29, 30 are available to only citizens of India. This is correct. Other fundamental rights such as 14, 21, 23, 24, 25, 28 are also available to all the persons irrespective of whether or not they are citizens of India. And again, statement 2 is also correct. All fundamental rights under Part 3 of the Constitution are enforceable against the state as per Article 12. And then ये जो state रो definition रे कौन bodies आस जाउचंती? Government and Parliament of India, state legislatures, local authorities and even government controlled bodies. अब एटा को judgment रे कुहा हितला R.D. Shetty versus International Airport Authority. ए कहितला कि government controlled corporation can also be considered as state under Article 12. So ये जो PSUs and all जहाँ भी government जो भी control अच्छी majority stake अच्छी they are also coming under state. तो यदि सेमाने भी किसी एपट सेपट हरकत कले people can go with their grievances to the Supreme Court directly under Article 32. Okay. So yeah, this was the 18th question. This is again a factual question. Who among the following described the DPSPs as the novel feature of the Indian Constitution? The answer is B.R. Ambedkar. Factual. Nothing to explain here. Who among the following filed the writ petition that led to the famous verdict of Supreme Court of India recognizing right to privacy as a fundamental right? very easy. Justice K.S. Puttasamy. He was a retired Karnataka High Court judge. Okay, Karnataka High Court judge. ଯେତେବେଳେ ଆଧାର ଆକ୍ଟ ଆସିଲା ସେଥିରେ ଆଇରିସ୍ ସ୍କାନ୍ ଫିଙ୍ଗରପ୍ରିଣ୍ଟ ଏଇସବୁ ଜିନିଷ ଯେତେବେଳେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ମ୍ୟାଣ୍ଡେଟରୀ କରିବାକୁ ଚେଷ୍ଟା କଲା ତ ହି ସେଡ୍ କି ନାଇଁ ଏସବୁ ମୁଁ କାଇଁ ଦେବି why will I give my so many personal details to the government, so he petitioned the court in this aspect and from there was a 9 judge bench. ये सब facts are important, they can ask anything, OPSC can ask anything. It was a 9 judge bench, 9 judge important लिख दिलेनी मु 9 judge bench led by Justice J.S. Kehar. Okay, unanimously gave, unanimously माने 9-0, looks like a hockey score or a football score. Unanimously said and 9-0 है कि से माने कहले कि yes, privacy is a fundamental right in India. Okay, as part of Article 21. तमे लोकों को बाध्य करि परिबनी कि तमे आधार देले ही हमें तुमको मैंडेटरी एटा दबो या सेटा दबो. हेंस आज का डेट रे आधार इज नॉट मैंडेटरी. ओके, इट इज जस्ट एन ऑप्शन. देई पारिबो न भी देई पारिबो. गवर्नमेंट कहउथला हमें सबुथरे आधार को मैंडेटरी करिबो, बट नो, आधार इज नॉट मैंडेटरी. एंड देन ए थ्रू ही बहुत आउरी जिंस बाहरला जेहेतु प्राइवेसी आसला तो परे नवतेज जौहर जजमेंट एलजीबीटीक्यू वाला. ओके, sexual rights, DNA profiling bill, ये सब aspects, this had a bearing on all these aspects. DNA profiling bill, ये जो आजिकली नुआ डिबेट स्टार्ट हेलानी, right to be forgotten, okay, right to digital privacy, cyber crimes, everything is interlinked. Okay, so this was a very landmark judgment जहाँ बेसर कि ए सब facts टिके जानिबाटा better. 9-0 JS Kehar, 9 judge bench, and yes, it overruled. आज पर्यंत ए टाइम पर्यंत privacy was not a fundamental right. Okay, it overruled 2 cases. One is the MP Sharma case, 1950s, exact date मुझे भूली जाऊँ, and the other one is the Khadak Singh case. आजिकली से मैंने सुप्रीम कोर्ट केसेस विषय भी पचारे तो यही सब भी टिके ध्यान ध्यान देवे. यही सब कहला कि प्राइवेसी इज नॉट अ फंडामेंटल राइट इन इंडिया. ओके, बट जिते बेले यही जज यही जो बेंच आसिला दे ओवर रूल्ड देम. these judgments effectively became redundant and hence this became the new reality of India. Okay, so that was question number 20. Moving on to question number 21. Consider the following statements. The concept of fundamental duties was adopted from the Soviet Constitution. This is correct. आमे तांको ठु एटा बोरो करछे. लक्ष्मीकांत रे गोटे बहुत बढ़िया टेबल दिया हेछि regarding this कि what has been borrowed from where. You should memorize it because this is a very regularly asked question. For example, emergency provisions were borrowed from Germany. Fundamental rights were borrowed from US and all those aspects. Same, the fundamental duties were borrowed from the Soviet Constitution. When eta kebe hitla? Eta 1976 during the emergency era. Swaran Singh Committee. Okay, Swaran Singh Committee, and originally there were 10 fundamental rights. Fundamental duties. My bad. Fundamental duties, and an 11th one was added, which is the next statement basically later. And this is the 42nd amendment. So these are the factual things that you should be aware about. The other countries like UK, US, France, they do not have a list of fundamental duties, but we do. Even Japan does, I guess. Yes, Japan does. So टिके टिके ये सब विषय रे आपण माने awareness रखिबा better. The next statement is the 11th fundamental duty was included by the 86th Constitutional Amendment Act 2002. This is again correct. 86th Amendment Act is famous for two things. One is 21A, right to education, RTE, and other is this 11th fundamental right, which is, this is basically the right of students or right of children. Okay, see same ଜିନିଷ କୁ କେମିତି ମନେ ରଖିବେ. This is right of children, this is the duty of parents. Same ଜିନିଷ, right of children, duty of parents. କ'ଣ ନା 6 to 14 years ଭିତରେ ଯେଉଁ ସବୁ ଛୁଆମାନେ ଅଛନ୍ତି ସମସ୍ତଙ୍କୁ education is important, ସମସ୍ତଙ୍କ ପାଇଁ education is a must. Okay, so 21A and fundamental duty. I can show it that to you here. Show that to you. See, this is fundamental duties. It shall be the duty of every citizen. Number 1 in this is the Bare Act, by the way. Okay, so number 1, this one it kon likha hai na inserted by the 42nd Amendment Act, which I just said. Okay, then it would 11th, this 2, number 2 added by the 86th Amendment Act. This is number 2. This is how the footmarks work. जे केबे Bare Act खोली की पढ़ी नाहंती. I'm just teaching you how to read the Bare Act. Okay, so who is a parent or guardian to provide opportunities for education to his child between the age of 6 and 14 years. So this is 86th Amendment 2002. This is 42nd Amendment 1, the whole chapter as a whole. So the answer is 1 and 2. Okay, yeah, so I'll be going forth between the constitution and our question paper from time to time. So take carefully dekhibe. This will be a very good learning in this whole process is how you should ideally be going about polity. Okay, moving on to the next question. Which of the following constitutional amendment attempted to give precedence to all the directive principles of state policy over fundamental rights? Okay, why this question? Because we know that DPSPs in general, at least according to the constitution, are not enforceable. Okay, so jodi lekha hai ki state should make policies for bringing UCC, okay, Uniform Civil Code. So a person cannot go and tell the court कि देखो state एमती काई करूनी एटा मोर right against ये हैला. No, सेटा तमे fundamental rights ପାଇଁ କରି परिबो. But जदि DPSPs under किछि provision अछि, that's up to the state किसी कोन जिंसो को execute करिवो and कोन जिंसो on paper will still stay. Okay, so which is why this question, which of the following wanted to give precedence to all the DPSPs over the fundamental rights? The answer is 42nd Constitutional Amendment Act. Let me give you the brief story about what really happened. So in 25th Constitutional Amendment, which is 1971, we are basically talking about. Ethi gote nuwa article add kala 31B. Article 31B add kala Parliament, where it was written that ki jodi if the Parliament basically brings a law which tries to execute or which tries to give force to 39B and 39C, okay, then they will be valid even if they take away Article 14 and 19. Okay, Article 14 is equality, Article 19 is free speech, movement, and all those aspects. Okay, what are 39B and 39C? Let me show them to you. Yeah, so this is the article 31B, validation of certain acts and regulation. Okay, I'm so sorry. This is actually 31C. Okay, 31B is the 9th schedule. My bad. This is 31C. Okay, so this language is a bit confusing, so you don't need to read that. We'll just straight away move to the 38, 39B and 39C. Yeah, so these are the two clauses. Jahaku ki jodi ame power delu Parliament kela, if we give these clauses the validation they require, then even if your right to equality and right to free speech or right to movement has been violated, you cannot approach the courts. Okay, why? Because this was a high time. You have to relate it with post-independent history. This was the high time of nationalization. Okay, एतोळकु land reforms पूरा full जोरशोरे चलची. And ebe government gote nuwa jinso start kala, which is nationalization of industries, nationalization of banks. Okay, amara socialist outlook is when government has all the control of the market, the industries, and all those aspects. Okay, ame Nehruvians, so Nehru, Indira Gandhi and all of them belong to the same school of thought. So they said ki nahi ame kiछि powerful industries purchase kariya ko dabani bahare, powerful private entities purchase kariya ko dabani. If someone is big, then we will just nationalize them, and then ame amo hisab re employment policies and all those aspects ra we'll take care of them. Okay. So nationalize करिया पाई ए जो दीटार जो जदि अपन words देखिबे, ownership and control of material resources. Now this material resources can be interpreted to be industries, banks, forest, land, everything. Okay. Mineral resources, everything. Mining ସବୁ ଏତିକି ବେଳେ start होची, ठीक ଅଛି. Okay. Then next is operation of the economic system does not result in concentration of wealth and means of production to the common detriment, which means nobody should become too big in terms of material wealth, in terms of concentration of wealth. ଆଉ ଯଦି ଆମକୁ ଦରକାର ଆମେ ସେଇ ଜିନିଷଟା ତମଠୁ ନେଇକି ତାକୁ ରିଡିଷ୍ଟ୍ରିବ୍ୟୁଟ୍ କରିପାରିବୁ ଲୋକମାନଙ୍କ ସାମ୍ନାରେ, ଲୋକମାନଙ୍କ ପାଇଁ, ଠିକ୍ ଅଛି. ସୋ ଏଇଥିରେ ଯଦି ତମେ ଆସିଲ ଆଣ୍ଡ କହିଲ କି ତମେ ମୋର ଇକ୍ୱାଲିଟି, ରାଇଟ୍ ଟୁ ଇକ୍ୱାଲିଟି ଭାୟୋଲେଟ୍ କଲ, या फिर मोर राइट टू फ्री ट्रेड वायलेट कल, ताले आम तुम कथा शुणबुनि, बिकज दिस इज कॉन्स्टिट्यूशनली प्रोवाइडेड. एंड द सुप्रीम कोर्ट सेड ओके दिस आई कैन एक्सेप्ट, बिकज सोशल जस्टिस एति दरकार. इंडिया रे पॉवर्टी लेवल इज वेरी हाई, तो जदि only the rich keep getting richer, then social justice won't be possible. So it allowed the government to do this. Now Indira Gandhi became very bolstered, very encouraged by this whole episode. And so what she said ki nahi hame not only 39B and 39C which you are seeing here, but we will try to give precedence to all the DPSPs over fundamental rights. Now this was struck down by the court. Okay, this is the correct answer, by the way. It attempted to, but later it was struck down in the Minerva Mills case. Okay, you should read about that case. बहुत बड़ा story तारा, so I won't say it here. But Minerva Mills case 1980, and after that the constitution went back to the same 39B and 39C, which is still the present position. Okay, 39B and 39C will have precedence over Article 14 and 19. And 80, Supreme Court said ki the constitution is found on the bedrock of harmony between fundamental rights and DPSPs. You cannot say ki DPSPs will dominate fundamental rights if social justice is involved. No, we have to find the right harmony between FR and DPSPs. And a case it said ki this whole thing is part of the basic structure of the constitution. Any attempts at violating this aspect will be deemed unconstitutional. So the answer is 42nd Constitutional Amendment Act. Okay. Just to run you through the remaining things, 44th to Thigachi, it was brought to undo a lot of things, whatever were done in the 42nd Act, 42nd Constitutional Amendment Act. Then the 50th and the 90th Constitutional Amendment Act. 90th is about Bodo land in Assam. Okay, it is related to Bodo land in Assam. 50th I am forgetting. Let's just check. 50th. Yeah, 50th Amendment. Power of Parliament to modify the rights conferred by this part in application to certain forces. Okay, so this is the 8th. देखो 8th अपन ओटे नुआ information पाइले. So सेट पाई options analysis पे important. Okay, so power of Parliament. This Article 33 has basically been inserted by the 50th Amendment Act, where Parliament has the power to modify the rights in their application to forces. Of course, forces कुछ एमती केतेटा माने इंडिया सीक्रेट्स एंड ऑफिशियल जिनस जना अच्छी जोटा कि जदि सेमाने एज राइट टू फ्री स्पीच जदि ब्रॉडकास्ट करिया स्टार्ट करदेले ताले आमर एज अ कंट्री आमर सीक्रेसी कौन हम एज अ कंट्री आम सिक्योरिटी कौन हम, राइट. सो फंडामेंटल राइट्स डू नॉट अप्लाई टू अस द सेम वे दैट दे अप्लाई टू द आर्म्ड फोर्सेस. So hence this article, and this article was inserted by the 33rd amendment. Okay. Then the 90th Constitutional Amendment, the same. We'll just, like I said, it's about, 90th. It's about giving representation to the Bodoland Territorial Areas District. Not very important. but this is how the constitution should basically be used while you are studying Lakshmikant. Okay, सब छोट छोट जिनस एमती जदि आपण थरे एठू भी देखि देबे ना तो conceptual understanding बहुत clear रहबो. ठीक अछि. Okay, the next question: which of the following statements is incorrect with reference to right to constitutional remedy? तळू start करिबा. देखिया कोटा कोटा correct अछि and then we'll come to the incorrect. The right to move Supreme Court for fundamental rights enforcement is itself a fundamental right. Yes, this is correct. Right to constitutional remedies, okay, is Article 32. So this right in itself is a fundamental right. So this is correct. Okay. Then suspension of Article 32 during national emergency is subject to constitutional limitations. Yes, this again is given in Article 359 that तमे सबू suspend करि परिबो. You can suspend a person's right to move the court. Okay, मान लिया. But if he comes to the court कि मोर Article 20 and 21 have been hampered, ताहले you cannot suspend it. Again, ସବୁ ଜିନିଷର ମୁଁ ଆପଣଙ୍କୁ ପ୍ରୁଫ୍ ଦେବି, ମୁଁ ଆପଣଙ୍କୁ କନସେପ୍ଚୁଆଲି ଭଲସେ ବୁଝେଇବି, ଏମିତି ଖାଲି ହାୱାରେ will not talk. Okay, so this is suspension of enforcement of rights conferred by part 3 during emergencies. Okay, where a proclamation of emergency is operation is nahi eta anway state to make power to yes, where an order made under clause 1 mentioning any of the rights conferred by part 3 is in operation except articles 21 20 and 21. Okay, so आपण माने तांकर पावर नहीं पारिबे, बट जदि से माने कहउचंदी कि मोर राइट टू लाइफ हैम्पर हेची कोर्ट पाखो एया कहि के आछन मोर आर्टिकल 19 हैम्पर हेची कोर्ट कैन से माने द प्रेसिडेंट के से कि नहीं तमे कोर्ट पाखो जाय परिबनी. आर्टिकल 14 हैम्पर हेची तमे कोर्ट पाखो जाय परिबनी. चलो मान लिया ठीक है, बट जदि मोर आर्टिकल 20 and 21 हैम्पर हेची, okay, then they can go to the court and get this under article 32. Okay, so this is also correct, but option here is incorrect, so let's keep looking for that. Yeah, high courts can issue writs under article 226 even for violations of legal rights beyond fundamental rights. Yes, eta bhi lekha hai, and this I can show you in just another couple of seconds. The incorrect answer is here. Supreme Court has the exclusive power to issue writs. No, High Court can also issue writs. Supreme Court can do it under 32. High Court can do it under 226. Okay, if I go back to my screen here, then let's go back to 226. ସେଇଠି ଆପଣ ଦେଖେଇବି କାହିଁକି ଅଲଗା ଲିଗଲ ରାଇଟ୍ସ ବି ଅଛି ହାଇକୋର୍ଟ ପାଖରେ. how do we know that? Okay, so the power of high courts to issue certain writs is the thing here. They can issue habeas corpus, mandamus, prohibition, quo warranto and certiorari for the enforcement of any of the rights conferred by part 3, which is fundamental rights, and for any other purpose. This is the key term that gives the power to issue these writs for any other purpose or any other rights apart from the fundamental rights, even for legal rights. Okay, but same jinsa Supreme Court pakhre nahi. Supreme Court can issue these rights only for fundamental rights. Eta ame kemti janiba? Now the Supreme Court shall have the power for habeas corpus, mandamus, prohibition, quo warranto, certiorari for the enforcement of any of the rights conferred by this part only. Only lekha hai ni, conferred by this part. Seti kon lekha hitla? Or for any other purpose, which means other legal rights also, but this for any of the rights in this part only the fundamental rights. So this is the key difference. This is how you know what is written where in constitution. This is where High Court gets that power to give extra writs for anything beyond fundamental rights. Okay, I hope you are enjoying this process. Okay, मुझे इमती refer करी करी पढ़ुची. I think you will get more things out of this exercise. Consider the following DPSPs. Which of the above are Gandhian is the question. Okay, so article 40, 42, 43, 46, 47, 50. This is a very factual question that you have to memorize. तो एथरे मु किछि माने as such किछि extra कोए माने कहि त किछि ये नहीं, just facts, just have a look at them. So what are Gandhian principles? Inspired by Gandhi's ideas of rural development, decentralization and self-sufficiency. এই সব জিনিস ঘোষিবার ଅଛି. Nothing much conceptual here. 40, 43, 43B, 46, 47. Just read them, what the facts are. Okay. Then socialist and liberal intellectual. Okay, so ଏଠି ସେମାନେ Article 42 and Article 50 କହୁଛନ୍ତି they are socialist and liberal intellectual. What is socialist? Say same, whatever it is, whatever it takes to make a egalitarian society. Okay, social justice ଆଣିବା ପାଇଁ. And liberal and intellectual, these are modern liberties, modern thoughts, ଯେମିତିକି marriage and all those stuff. तो आ भिତରେ भी କେତେଟା ଜିନିଷ ଆସି ଯାଉଛନ୍ତି and आ भिତରେ भी କେତେଟା ଜିନିଷ ଆସି ଯାଉଛନ୍ତି. So again, everything given in Lakshmikant, all these questions has been remember, constitution does not make this differentiation. Okay, this is done by experts. This Gandhian, socialist, liberal, intellectual, ये सब कोठी constitution रे लिखा है नहीं. ये समस्त experts करो view that okay, ए 3 types रो DPSPs अच्छी, and in this question you had to identify इनमें से कौन सा is Gandhian. Okay, so constitution does not make this differentiation. Yeah, एमती किछि word constitution रे नाही. Again I am telling you, जदि सेमाने कहि देले according to the constitution, Article 44 is a liberal intellectual principle. No, Article 44, which is UCC, is not a liberal intellectual, because according to constitution is the wrong statement. So ସେଇଟା ଆପଣ ମାନେ confuse ହେବେନି, because it is a liberal intellectual, but constitution does not make this differentiation. Okay, be careful about that. Consider the following statements regarding constitutional writs in India. Again, a question back on writs. The writ of certiorari can be issued to quash administrative orders that violate principles of national justice. Yes, again, तारो किसी explanation constitution रे नहीं, but एटा हमें these are legal instruments और तारो explanation given in the book. Certiorari is given by a higher court to a lower court. Okay, जितेवेले ये lower court has not given someone the chance to be heard, has violated his principles of natural justice. For example, imagine जड़े गवर्नमेंट स्कूल टीचर, ओके, हठात तांको गोटे लेटर आसुची, योर सर्विसेस आर नो लॉन्गर रिक्वायर्ड. ओके, एंड द some tribunal or some lower court says your services are no longer required, you are hereby suspended, you are hereby terminated. So this person goes to the Supreme Court or the High Court for that matter, okay, for enforcing his fundamental right. The Supreme Court can tell that lower tribunal or court कि अरे तुमने उसको चांस सुनने का मौका ही नहीं दिया, तुमने उसको सुनने का मौका ही नहीं दिया, क्यों सस्पेंड किया उसको, क्यों उसका टर्मिनेशन लेटर उसको दे दिया. ठीक है, उसको सुनने का मौका तो दो, उसने ऐसा क्यों किया या उसने क्या किया. You have not given him any explanation, you have just rusticated him or terminated him. So this particular order is certiorari, and this is exactly what is written here. The writ of certiorari can be issued to quash administrative orders that violate principles of natural justice. This statement is correct. The writ of mandamus can be issued against private individuals for enforcement of private rights. No, this statement is wrong. What is mandamus? Mandamus is when a body or a court reminds another body to basically do its job properly. Okay, so ମୁଁ ଏବେ OPSC ପାଇଁ apply କରିଛି, ମୋର OPSC एग्जाम ଦେଇକି ବସିଛି, ସବୁ ବସିଛି, 2 ବର୍ଷ ହେଲା ରିଜଲ୍ଟ ଆସୁନି. ତ ମୁଁ ସୁପ୍ରିମ କୋର୍ଟ ପାଖକୁ ଗଲି କି ଆରେ ମୋର ବୟସ ହେଉଛି, ମୋ ଫ୍ୟାମିଲିକୁ ମୋତେ ପୋଷିବାର ଅଛି, ମୋତେ ଚାକିରି ମିଳୁନି, एंड ये माने रिजल्ट बाहर କରୁନାହାନ୍ତି, OPSC वाला रिजल्ट बाहर କରୁନାହାନ୍ତି. तो सुप्रीम कोर्ट कैन इश्यू अ मैंडेमस टू OPSC कि डू योर जॉब, what are you waiting for. Okay, so that is mandamus. Okay, but it cannot be given out to private individuals. ମୁଁ ଏବେ ଗୋଟେ ଘର, ମୋର ଏବେ ଲିଜ୍ ଏକ୍ସପାୟାର ହେବାର ଅଛି, ଅଗଷ୍ଟରେ ଲିଜ୍ ଏକ୍ସପାୟାର ହେଇଯିବ, बट एंड मत ओनर कौच कि नुआ घर देख मु ए घर को बिकिया जाऊँगी, तो मु ओनर को कहबी नाई नाई मो पाखे आउ किसी घर कौटी रही ना, प्लीज मोर लीजटा एक्सटेंड कर. द ओनर सेज नो. नाउ इफ आई गो टू द सुप्रीम कोर्ट नाउ Supreme Court cannot help me because this is a purely a choice of the owner. Okay, Supreme Court cannot tell the owner कि ना तमे ता lease extend करो मु तमु कहूची ता lease extend करिया पे. No, it cannot be given to private individuals. एटा ता right, एटा ता fundamental right to do whatever he pleases. So you have to look for a new place. That is on you. तमे चाहिए government shelters use करो किसी दिन पाए, but you have to find your own place. So private individual secondary, this cannot be given. So this is one only. Okay, moving on. Which of the following provisions of the Indian Constitution explicitly mentions the concept of martial law? Eta mu direct dekhe bhai better raheba am pai. Article 34 is the answer. Restrictions on rights conferred by this part while martial law is in force in any area. Okay, so this is Article 34. Martial law bisare, this is the only place where martial law bisare kichi mentioned ache in the Constitution. You know what is martial law? ଯେତେବେଳେ army rule लागू हो जाउछ. If there is a law and order situation where the local police has failed, the paramilitary forces are called in or the army forces are called in and they are asked to look after the law and order situation. So that is when martial law comes in. Okay, and sorry, screen change karine, my bad. Which of the following provisions explicitly mentions the concept of martial law is the question. Okay, army rule and martial law. So jaha ithre likha hai, this is basically the question. The answer is Article 34. So what is basically written in this act is nothing, notwithstanding anything in the foregoing provisions. Notwithstanding mane ta mane basically hoche in spite of. Okay, so in spite of anything that has been given in this part, that is part 3, the union or a state, the parliament by law may indemnify any person. Indemnify माने होची protect. Okay, protect any person. माने धरो martial law रे कौन हला for some law and order thing से माने tear gas use कर ले और rubber bullets use कर ले ताकि law and order under control आसे जाओ. But tear gas and rubber use करिया जो गुरु, someone lost his eyesight. This has happened in Kashmir also, if you remember. Or someone maybe lost a leg, or in the worst case someone lost his life. Okay, can that person who did that under that pressure situation be punished? They can be punished if they are found to act outside the authority, but it is likha that the parliament may by law indemnify any person. That empty law ani paribo parliament where they can protect that person from any kind of punishment because they were acting under orders and it was necessary to do so, otherwise sethi riots he jaithanta, otherwise sethi ahuri besi matrare life loss and property loss heithanta. Okay, so this is what Article 34 is all about. Okay, again camera somehow change karni mu ଟିକେ switching back and forth रे mu ଟିକେ confuse he जाउची, so don't mind, just outre कहि दउची. Parliament may by law indemnify any person. This is what Article 34 is all about. Notwithstanding माने होची in spite of, indemnify माने होची protect any person. So that is what is written in this article. Okay, I have to consciously switch between the two screens. मुझे एक्स्ट्रा किसी नुआ जिनसे करिया चेष्टा करूँ तो I have to be prepared accordingly. Question 27. Question number 27. Article 21 of the Indian Constitution guarantees the right to life and personal liberty. Okay, this is an assertion reasoning type question. Assertion reasoning में आपने को data statement दिया है थिबो. Okay, and you have to tell me if this statement is explaining this statement. First of all, identify if this is true or false. Then identify if this is true or false. If both are true, then tell me if this explains this or not. Okay, so say hisabri these 4 options will always be same, and accordingly you have to mark what option is appropriate for the question. Okay, so Article 21 of the Indian Constitution guarantees the right to life and personal liberty. This is correct. The right to life under Article 21 cannot be suspended even during an emergency. Even this is correct. Article 358, 359 re likha hai. Okay, but this is not explaining this. These are two standalone facts. This is a standalone fact. This is a standalone fact. Okay, the best trick to solve these questions is first read this statement. Okay, first read this statement. The right to life under Article 21 cannot be suspended even during an emergency. Okay, Hence, Article 21 of the life of the Indian Constitution guarantees the right to life and personal liberty. No, it does not make any sense. जदि ये ताको explain करथांता then गोटे hence या फिर so या फिर therefore रे आमे इस statement दिटा को connect करि परथांते. Okay, but एथि किछि connection बसुनी सेटा जबरदस्ती लाउच. So hence these are just two statements. Both A and R are true, but R is not the correct explanation of A. This should be the answer. Okay, very straightforward. A very factual question. Arrange the following committees in the correct chronological order of their formation. Swaran Singh, JVP, Sarkaria, States Reorganization Commission. There's a factual jinso, to ethri kichi story ko kayar nahi, so let's just read the solution. Okay. JVP Committee, 1948. States Reorganization Committee, 1953. Swaran Singh, 1976. And Sarkaria, 1983. Okay. JVP for linguistic reorganization, states reorganization for reorganization of state boundaries, Swaran Singh for fundamental duties, Sarkaria for center-state relations. This is the order. Ahuri mojire ketara sabu jaha committees aschi, everything given in Lakshmikant. Just remember their ears because ei bhaliya notorious factual questions by OPSC is famous, or let's say infamous. Okay. Another assertion reasoning question. Article 31B of the Constitution protects the acts and regulations. Let me use the highlighter. Protects the acts and regulations included in the 9th schedule. Okay. From being challenged and invalidated on the grounds of contravention of fundamental rights. This is correct. कौन तारो मने माने and all details कौन इतने complex statement बुझे भी. According to the Supreme Court's ruling in IR Coelho case, laws placed in the 9th schedule after April 24, 1973 are open to judicial review if they violate basic structure. This is also correct. So let me give you a brief story about the whole 31B thing. Okay. So what happened? जेतेला में यहाँ पे गोटे fresh page नहीं गले better होगा. इटी ते कम जगह लिखला I'm facing trouble. Yeah. So what happened? जेतेबेले when we started those land reform things, okay, land reforms anlu ame, okay, this is the 50s we are talking about, 1950s we are talking about. Land reforms jetele anile etebeku out a fundamental right which has now been deleted, but setebele it was present, that was right to property. Okay, so right to property was a fundamental right. आम जो लैंड रिफॉर्म्स आणले, लैंड रिफॉर्म्स वाज कि जहाँ पाखे अधिका जमी अच्छी ताठू नियो, एंड जे सब जहाँ पाखे जमी ना, जो गरीबी अच्छी जहाँ पाखे प्रॉपर्टी ना, लैंड ना, टाइटल ना, तांको रीडिस्ट्रीब्यूट करो. दिस इज द होल लैंड रिफॉर्म प्रोसेस इन अ नटशेल. ओके, सो ये जो जहाँ सब निया है 300 एकर क्या पाखे थिला, ताठू आम 270 एकर नहीं कि ताकू देले तू 30 एकर रख, आ 270 एकर को आम 27,000 जन भितर बांटी देलु. तो एमाने तो खुशी गले, बट यही जो लोकटा तारो राइट टू प्रॉपर्टी वाज हार्म्ड, ओके, वाज वायोलेटेड. ही वेंट टू द कोर्ट कि देखो मेरा ज़मीन ले गए. ओके, द कोर्ट, हाई कोर्ट, सुप्रीम कोर्ट, इन मैनी केसेस सम कोर्ट सेड ठीक किया, बट मैनी कोर्ट्स ऑल्सो सेड नहीं, गलत किया. ओके, येस, राइट टू प्रॉपर्टी हैज़ बीन हार्म्ड हियर, लैंड रिफॉर्म्स इज इलीगल. ओके, बहुत सारा कोर्ट्स कहले कि लैंड रिफॉर्म्स आम अलाउ करूनी बिकज तुम्हें ही कह फंडामेंटल राइट टू प्रॉपर्टी इज अ फंडामेंटल राइट, तो आम केमती अलाउ करदेबू, तुम्हें ता फंडामेंटल राइट खाऊच ना. तो पार्लियामेंट कौन कला कि जो 9th शेड्यूल गोटे जिनसटे आणला. ओके, दिस इज 31B. ये जो जिनस मुझे देखी 31B, validation of certain acts and regulations. Okay, none of the acts and regulations specified in the 9th schedule, okay, shall be deemed to be void, okay, on the ground that they are inconsistent with or take away or abridge any of the rights. माने बुझले, जदि आमे गोटे लॉ आनिलु, एठी 9th schedule अच्छी, ओके, ये जो लॉ टाको जदि आमे एठी प्लेस कर देलु, हरियाणा लैंड रिफॉर्म्स एक्ट, पंजाब लैंड रिफॉर्म्स एक्ट, दिस लैंड रिफॉर्म्स एक्ट, व्हाटएवर, जदि एई लिस्ट रे आमे ताको प्लेस कर देलु, देन you cannot come and say कि my fundamental right has been violated. none of the acts and regulations specified in the 9th schedule shall be deemed to be void. Okay, if they are inconsistent or abridge or take away any right provided in this part, which is part 3. Okay, so this is what they did. 9th schedule 8th ପାଇଁ ଆସିଥିଲା. सो आर अगेन फायदा उठेगी कौन से माने करिया स्टार्ट कले लैंड रिफॉर्म्स छोड़ा आहुरी एमती बहुत सारा क्वेश्चनेबल एक्ट्स आणले जाको कि जस्ट जुडिशियल स्क्रूटिनी पास करिया पई से माने जबरदस्ती नहीं खाली 9th शेड्यूल रे थोतले. ओके, सो केशवानंद भारती केस रे सुप्रीम कोर्ट कहला कि हाँ ठीक अच्छे आम मानिलु यू आर डूइंग दिस फॉर सोशल जस्टिस, यू कीप डूइंग इट. ओके, बट जुडिशियल रिव्यू विल स्टिल अप्लाई. तो आम जो कह जुडिशियल रिव्यू भी आम हवा को दबुनी. एटी कौन लिखाई ये लिखाई लास्ट लाइन रे एनी डिक्री और ऑर्डर ऑफ एनी कोर्ट और ट्रिब्यूनल टू द कॉन्ट्ररी each of the said acts and regulations shall, subject to the power of any competent legislature to repeal or amend it, continue in force. जदि किसी कोर्ट ऑर्डर भी देला to repeal or to amend it, despite this it shall be continued, it shall be in force, it shall continue to be in force. तो सुप्रीम कोर्ट कहला no, I cannot let you do that. जुडिशियल रिव्यू आमे करिबु. ओके, जदि हमको देखागला कि नहीं दिस इज नॉट इनकन्सिस्टेंट विथ this is not consistent with the basic structure, tale we have the right to deem that thing unconstitutional. Okay, so this is the whole story of article 31b. Article 31b of the constitution protects the acts and regulations included in the 9th schedule from being challenged and invalidated on the grounds of contravention of fundamental right. This is correct. According to the Supreme Court's ruling in IR Coelho case, laws placed in the 9th schedule after April 24, 1973 are open to judicial review if they violate the basic structure of the Constitution. This date is basically the KB case date. Okay. So anything, any law that has been placed in the 9th schedule after the KB case, after this hearing, is open to judicial review. If we find ki there are certain clauses which are not consistent with the basic structure. So this is a factual thing. Now, is it explaining this thing? No. Again, these are two standalone facts. This is a standalone fact. This is a standalone fact. This is not explaining this thing. This is true. This is again true. But since this is this, hence this is the case. No, we cannot say that. So again the answer becomes both A and R are true, but R is not the correct explanation of A. I hope you get the picture. Okay, ये जो तमिलनाडु रा, if you know about तमिलनाडु, 69% reservation अच्छी तमिलनाडु रे. Okay, से माने ये लॉ टाको 1994 रे आनी थिले, ताकू बहुत चालाकी रे 9th शेड्यूल रे जाइए प्लेस कर देइचंती. ओके, माने आओ पूरा इंडिया रे जोटी 50% फॉलो होची एबे तो 60% थैंक्स टू EWS. तमिलनाडु रे 69% इज अलाउड बिकॉज तमिलनाडु साइड आमर सोशो इकोनॉमिक कंडीशंस अलगा, आमर सब तमिल मीडियम छुआ तो से माने इंग्लिश मीडियम छुआ संगे कंपीट करि परिबेनी, हेंस हमको 69% दरकार. आज पर्यंत ए केस इज सब जुडिस. ओके, एंड हेंस तमिलनाडु कंटिन्यूज टू हैव दिस प्रोविजन. सब जुडिस माने इट इज इन कोर्ट, पेंडिंग इन कोर्ट. कोर्ट तक बहुत थोड़ा कही मत डेटा दियो, मत ये दियो, मत से दियो, मत लिटरेचर दियो टू प्रूव दैट व्हाट यू आर सेइंग. से माने केबे करना हती. 2016 रे गोटे पिटिशन फाइल हेजी, 2021 रे गोटे पिटिशन फाइल हेजी, बट ड्यू टू सम पॉलिटिकल रीजंस बियॉन्ड द स्कोप ऑफ आवर अंडरस्टैंडिंग it has remained sub judice for almost 30 years now and it continues to be so. This is actually directly related to the whole NEET issue. If you know what the NEET Tamil Nadu issue is, okay, tanko kaya kotha NEET is favoring CBSE board is for in general for English medium students जो माने बुझी पारुचंती and CBSE रो जो माने पढुचंती. बट आमर एठी मैक्सिमम पिला माने जे 10th 12th पर्यंत आसुचंती से माने 69% रिजर्वेशन सिस्टम वाला सब तमिलनाडु बोर्ड्स रो आसुचंती. सो से माने नीट पिला संगे कंपीट करि परिबेनी. तेणु आमे आमर अलगा एग्जाम करिवु मेडिकल बोर्ड पे, तमे तमरो अलगा एग्जाम, तमे तमरो नीट करो. तो दिस इज द होल इशू which the president did not allow. So एबे तमिलनाडु रे प्रेजेंटली नीट ही होची, बट तांकर रिजल्ट्स वगैरह सब बहुत ड्रास्टिकली इंपैक्ट हेची. ए जो स्टेट बोर्ड छुआ माने मेडिकल कॉलेजेस रे एडमिशन पाउ नाहंती. ओके, And this is what Mr. Stalin, the chief minister of Tamil Nadu, keeps raising the issue about. So this was about schedule 9, ninth schedule. Which of the following statements regarding the constitutional amendment procedure in India is are correct? Okay, ठीक है, देखते हैं क्या पूछ रहा है. An amendment under Article 368 can be initiated only in the Lok Sabha. No, it can be done in the Rajya Sabha also. Okay, so this statement is wrong. Some constitutional amendments require ratification by at least half of the state legislature. Yes, all the federal features. I mean, go to question agro eta discuss korche ame. Okay. The president is bound to give assent to constitutional amendment passed by the parliament. Is bound to. How do we know is bound to or has the choice? Through the constitution. Let me show you. Okay. 368. Yeah. So 368 is part 20 of the constitution. Agu तार गोटे question अछि तो ए बिट मु कहि दोछि part 20 of the constitution amendment, power of the parliament, something is written. Then जेतेबेले लिखा अछि an amendment to the constitution may be initiated by introduction of bill for the purpose in either house of the parliament. Amar statement 1 कोन थिला? Can be done in Lok Sabha only. So that is wrong. It 80 prove हेगला either house of the parliament. आगे बढ़ते हैं. And when the bill is passed in each house by a majority of total membership of that house and by a majority of not less than 2/3 of the majority of the members of that house present and voting, this is the majority that is required, half of the total and 2/3 of those present and voting. You know this. Okay. It shall be present to the president who shall give his assent to the bill. Okay. एटी जदि लिखा था who may give to his assent. Okay. Or who may give it or return the bill. Then ei sabu jinsa amku tike mane president को extra power देता to do something about constitutional amendment act. But since it is written here, the president shall give his assent, that makes our statement here, the president is bound to give assent as a correct statement. Okay. Some constitutional amendments require ratification by at least half. This is also correct. This is also correct. The answer is 2 and 3. An amendment under 368 can be initiated only in the Lok Sabha is a wrong statement. So this is the constitutional connect. If I can read the solution, this is question number, yeah, this one, 30. This is wrong. This is correct. Third one is correct. And these are the articles जो कि half the state legislature हमको ratification दरकार. 54 and 55, election to president of India. 73 and 162, union judiciary, high court. All these articles बहुत ही पॉसिबल क्वेश्चन यूपीएससी डायरेक्ट एमती आर्टिकल खाली आर्टिकल नंबर दे दबो ता सामने रे किछि कहबो एटा आर्टिकल कोन कोन नाही जस्ट आर्टिकल नंबर दे दबो आ कहबो मते कुह एथरे स्टेट रैटिफिकेशन दरकार ना नाही. So just go through them, memorize them. It's very important because these are the kind of factual questions that they are famous for asking. Okay. Okay. Which of the following best reflects the Supreme Court's view on the power to amend the Constitution as laid down in Keshwananda Bharati? This is a very simple question. We have freebies bhi diye so that nobody gets a 0. Okay. The correct answer is this. Parliament can amend any provision but cannot alter the basic structure. Eta samaste janchandi. Ethi lekha itla unlimited power, which is wrong. Parliament can amend the Constitution only with the consent of states, which is wrong. Constitutional amendments are not subject to judicial review once enacted, which is wrong. बहुत सारा constitutional amendments आसची और ताकू Supreme Court strike down करिछि. जोटा कि मु कहली 42nd amendment रे जेतेबेले से माने DPSP को जेतेबेले precedence दवा को चेष्टा कले fundamental rights को, so Supreme Court in Minerva Mills case said no, we won't allow this. Okay. So this is also wrong. This is the correct answer. Very simple. Which of the following directive principles of state policy was added to the Constitution via 97th Constitutional Amendment Act? This one is famous for cooperative societies. Constitutionalization of cooperative societies. 97th Constitutional Act. And the answer here is 43B. हमारा काम है आपको प्रूफ दिखाना है ना. So आपको प्रूफ देखेबा पई I'll go to 43B and I'll show you the screen. So this is promotion of cooperative societies. 80 गोटे 1 लिखा है. Okay, this 1 80 तळकु जिबा लिखा है 97th Amendment Act. Okay. The state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. This is that. Apart from this, they added the same thing to, they added cooperative societies to another chapter also. Okay. Here. Part 19, no, Part 9b, the cooperative societies. Part 9b, the cooperative societies. Again, जदि एठी जो 1 जदि तमे देखिबो 1 लिखा हैछि 97th Amendment Act 2011. So ये जो 243ZH, 243ZI, 243ZJ, all these aspects, ये जो part रे आछछि 9b, तमे जदि क्वेश्चन पचारला you can answer 97th Constitutional Amendment Act. Okay, moving on to the next question. Which of the following are fundamental duties under Part 4A of the Constitution of India? Fundamental duties हमको recognize करियार अछि. Simple enough. To safeguard public property, yes. To strive towards abolition of untouchability, no. This is Article 17. This is a fundamental right, not a fundamental duty. To uphold and protect the sovereignty and integrity of India, yes. To promote international peace and security, no. This is Article 50 or 49 maybe. 50 is, I think, separation of judiciary and executive. This is 49, I guess. Guess करिया कौन सी चेक कर दवा ना पाखे कॉन्स्टिट्यूशन रो बेयर एक्ट हम पाखे खोला है पूरा. Yes, separation of judiciary from executive is at Article 50. This is 51, not 49. My bad. Promotion of international peace and security. The state shall endeavor to promote international peace and security. So this is Article 51. This is not a fundamental duty. This is a DPSP. So that also makes it wrong. The answer is 1 and 3. Confuse करिया से माने एमती चेष्टा करिवे. What is fundamental duty? What is DPSP? What is fundamental right? तो सबू जिनस विषय you have to have utmost conceptual clarity, utmost factual recall ability as much as possible. Okay, you cannot go wrong in these questions, otherwise you will be in for trouble. Because यदि एई questions भूल हे जाउची ताल तो जो कॉम्प्लेक्स क्वेश्चंस आसीबो, जो फैक्चुअल क्वेश्चंस आसीबो, सेटा तो हमें छाड़िया, सेटा तो हमें भूल करके आसीबा ही. माने समस्त तो ठीक क्वेश्चन करि परिबेनी, सब तो आपनु जणा नथिबो. एमती तो आजिकल आज पर्यंत केही महापंडित जन्म हे नांती जे 200 रु 200 रख दबो, राइट. तो एमती तो क्वेश्चंस आसीबो ही, बट एई क्वेश्चंस रे भूल करबा इज गोइंग टू बी कॉस्टली. इट्स गोइंग टू कॉस्ट यू अ ईयर ऑफ योर लाइफ. इट्स एज सिंपल एज दैट. ओके. Article 21. With reference to Article 21, consider the following statements. The right to die with dignity has been recognized under Article 21. Yes, this is a recent one. Recent one inside last 5 years. This common cause case. Okay. These सब cases eventually will help you in mains. So you should know them. This is common cause case. Passive euthanasia. Right to die with dignity. Okay. This is 2018, I guess. Yes. Protection under Article 21 includes right against solitary confinement and custodial torture. This is the Sunil Batra case. Sunil Batra versus Administration of Delhi. So this is also correct. Article 21 was originally interpreted narrowly in the A.K. Gopalan case. Yes. This eta I think gote purbo question re bhi कहली. Procedure established by law को सेमाने बहुत narrowly interpret करथिले, which was later undone by the Menaka Gandhi case, where they said कि नहीं खाली जहाँ कागज रे लिखा है सेया नुहे, हमें ता fairness उपरे भी चिंता करिबा, and they brought in due process of law. Okay, so this is also correct. The term right to education was originally part of the Article 21 before 86th Amendment. No, this is just given to confuse you. 86th Amendment रे ही right to education 6 to 14 years छुआंग पई आसेला. एबे हमें पूर्व क्वेश्चन रे डिस्कस कले. 21A रे ताको insert कले as a right for children. 51A, which is fundamental duty रे ताको insert कले as a duty of parent. The same amendment, the same wordings, just as a right here, as a duty here. Right of child, duty of parent. Okay. So this is wrong. This makes the answer 1, 2 and 3. Okay. Which of the following provisions require amendment by a special majority of parliament and ratification by half of the state legislatures? एई पूर्व क्वेश्चन रे आमे या विषय कोन डिस्कस करथिले बोधे an amendment some constitutional amendments require ratification by at least tare related ethi ode question asla since this is a sectional test and I have a limited bandwidth of how many areas I can ask questions on. So एमती केतेटा topics repeat होची केतेटा topics रे depth को आहुरी बेसी पसुचे so that exam oriented preparation माने हेई चलिबो. Which of the following provisions require special majority and ratification by half states? So say सेठी हमें देखिले 55 was right, Supreme Court was right. This is incorrect. Abolition of legislative councils in states under 169 is not required to be ratified by half the states. तो जदि मु माने सिंपल कथा जदि मु तमिलनाडुर लेजिस्लेटिव काउंसिल को अबॉलिश करिया जाउची या वेस्ट बंगाल पंजाब रो लेजिस्लेटिव काउंसिल को अबॉलिश करिया जाउची, why will I need the ratification of 15 states, Gujarat and all those things? Okay, so just a minute. Okay, so this is wrong. 333 is wrong. 1 and 2 are correct, and these are basically federal features. Okay, why federal features? Because election of president रे state legislative assemblies रो भी vote count होची. Okay, तो जदि काली को एटा को से माने manner of election को से माने unilaterally amend करि देले and कहले कि ना कल ठो हमें state legislative assembly रो vote को count करिबानी से जो प्रेसिडेंशियल जो कॉलेज ऑफ इलेक्टर्स रे से तमन रहबनी खाली आमे पार्लियामेंट वाला रहइबो तो स्टेट वाला किछि करि परिबेनी हेंस आकु जदी से माने अमेंड करिया को चाहूचंती तो हाफ द स्टेट्स रो रैटिफिकेशन भी दरकार हेंस इट इज अ फेडरल फीचर द सेम विथ जुरिसडिक्शन ऑफ सुप्रीम कोर्ट ओके this is the logic behind it. This is 1 and 2. Am I missing out on something in this question? तो ये आम लास्ट क्वेश्चन देख ले कॉमन कॉज सुनील बत्रा ए के गोपालन मेनिका गांधी 86th okay no nothing missed out in this question. This ensures federal balance as president represents both union and state. This is statement number 1. Again, jurisdiction of Supreme Court is part of the federal structure, hence this is statement number 2. Both are correct. Abolition of legislative council is amended by simple majority of the parliament. एथरे किछि ratification वगैरह दरकार नाही. ठीक अछि. आर्टिकल 169 चाहिए आप खोलिकी पढ़ी भी पारे मुझे सब क्वेश्चन जब ये खोलिया मैंने स्टार्ट करदेवी देन 3 घंटा 4 घंटार वीडियो हम तो जोड़ा जोड़ा बेसी इंपोर्टेंट आई ओपन दोज अप. ओके सो विच ऑफ द फॉलोइंग पार्ट्स ऑफ द कॉन्स्टिट्यूशन रिलेट टू अमेंडमेंट ऑफ द कॉन्स्टिट्यूशन एबे जो देखी आप जो से स्क्रीनशॉटा देखी आर्टिकल 368 दिस पार्ट 20. सो द आंसर इज पार्ट 20. simple enough. Article 20, okay, this is another assertion reasoning question. Let's see if it be answer B or not. Okay, let's see. जो दीटा आछी हमर आंसर B रोची for some reason, but एटा देखिया कोन होची. Article 22 of the Indian Constitution provides safeguards for both preventive and punitive detention. Correct. 22(1) ru 4 for punitive, 22(4) ru 7, 22(1) and 2 for punitive, 22(4) to 7 for preventive. Okay, I hope you know what is punitive and preventive. Punitive is when you are trying to punish someone. Preventive is when someone is trying to do something in advance. Okay, preventive detention, मुझे कोई अरेस्ट करने वाला है, मुझे कोई डिटेन करने वाला है, मुझे ऐसी फीलिंग आ रही है जज साहब, तो आप मुझे मुझे आप उससे बचाओ. ठीक है. एंड प्यूनिटिव डिटेंशन, मुझे गिरफ्तार कर लिया गया है जज साहब, तो आप मुझे बचाओ. तो दीटा बस एती की स्मॉल डिफरेंस. बहुत सारा हिंदी मूवीज रे यू हैव सीन दिस. ओके. आर्टिकल 22 guarantees the right to be produced before a magistrate within 24 hours and imposes limitations on preventive detention beyond 3 months unless approved by an advisory board. All these facts are correct. Now let's see if we can say कि because this is so, hence this is so. ये जो rule term आपन कहिछि, let's see if we can do that. So Article 22 guarantees the right to be produced before a magistrate within 24 hours and also impose limitations on preventive detention beyond 3 months. Hence, Article 22 of the Indian Constitution provides safeguards for both preventive and punitive detention. We basically proved this by using this. which means the answer here is A. Yes, both are true and R is the correct explanation of A. Okay, sectional test 1, this is the solution. 22.1 and 22.2 provide safeguards for persons arrested under ordinary law, which is punitive detention. The safeguards include right to be informed of the grounds of arrest, right to consult a legal practitioner. मुझे मेरा वकील चाहिए, मैं अपने वकील से बात किए बिना जेल नहीं जाऊंगा, ये जो सब डायलॉग्स, ये सब फंडामेंटल राइट्स, ये सब से मैंने हवारे को नहंती, ये मेरा अधिकार है, ये अधिकार कहाँ लिखा है, ये अधिकार आर्टिकल 22 में लिखा है. ओके, right to consult a legal practitioner and right to be produced before magistrate within 24 hours. All these are written down in the constitution. And then article 24 to 22.4 to 22.7 provides safeguards for persons detained under preventive detention laws. Okay, कि तुम कल को जाके कुछ बड़ा ना कर दो, कुछ आतंकी ना कर दो, कुछ हमला ना कर दो, कुछ बॉम्ब ना फोड़ दो, इसीलिए हम तुमको पहले से ही गिरफ्तार करना चाहते हैं. दैट इज प्रिवेंटिव डिटेंशन. ओके, टू प्रिवेंट समथिंग. Guarantees the right to be produced before nearest magistrate within 24 hours of arrest, and this is that advisory board, this thing. And so by giving specific examples of how article 22 addresses both situations, reason R effectively demonstrates how assertion A is true. Okay, so ମୁଁ ସବୁ ବଲିଉଡ୍ ବଲିଉଡ୍ ସାଙ୍ଗେ ସବୁ କନେକ୍ଟ କରିକି ମୁଁ ଏଇଟା ପଢ଼ିବାକୁ ଚେଷ୍ଟା କଲି. I hope your concepts are clear. This is both A and R are true and R explains A. So ଏଇଠି ଆମର I think polity question ସରି ଯାଉଛି. ଏଇଠୁ current affairs question start ହେଉଛି. Every sectional test ରେ ଆମେ we keep a mix of 40, 10 or 39, 11. Core subject 40 questions, 10 questions current affairs, so that your current affairs prep is not left behind. So from here on it is going to be a breeze. ଏଥିରେ କିଛି story वगैरह बेसी ନାହିଁ. ଯଦି କିଛି extra facts କହିବାର ଥିବ ମୁଁ କହିବି. Other than that, otherwise we will just read through the solution and quickly finish these next 12 questions. Maximum 12 minutes. Okay, let's go. Which of the following schemes aims to enhance the sustainable management of wetland across India and India through community participation? The answer is Amrit Dharohar scheme. Eta asthila budget 2023 re. Okay, and tar whole purpose was sustainable management of wetlands. So here Union Budget 23-24, Amrit Dharohar scheme, sustainable management of wetlands, particularly the Ramsar sites. Okay, then goal of Amrit Dharohar is to promote unique conservation values of Ramsar sites and all the generic content which is basically written so that solution बहुत छोटो न देखा जाओ, ठीक है, बड़ो देखा जाओ. But other than that, a question रे सेमती किछि नाही. But if you want some extra information on this, then let me give you some recent updates. एबे इंडिया रे can anyone tell me how many Ramsar sites do we have? Recent माने मु एटा जून 26 को रेकॉर्ड करछि, तो मु एटा जून 26 हिसाब रे पचारछि. हुए तो काली से माने आउ पांचटा खंडे ये कर देबे and this whole information becomes outdated. But आज का डेट रे we have 91 Ramsar sites. Okay, this is one fact. Other fact, first Ramsar site Chilika and I think Keoladev. Okay, 1981. Then number 3, state with the most Ramsar sites. Most is equal to Tamil Nadu, 20. Okay, second most is equal to UP, 10. ये सब facts are important. Keep noting them down because it सब solutions लिखा है नहीं. ठीक है. Then Odisha रो खाली जदि आमे देखिबा केतटा अछि. Odisha रे अछि 6टा. What are those? This is Tampara in Ganjam, Tampara Lake, Onusuppa Lake in Cuttack. Then you have Hirakud in Sambalpur, I guess. Yes, Sambalpur. You have Satkoshia in Onugul. I hope I'm not getting these places wrong, otherwise लोग को मुझे बाड़े हुए. Then Bhitarkanika in Kendrapada, and you have Chilika in Chilika, of course. Okay, so these are the 6 places in Odisha which are the Ramsar sites. So these are some facts. I don't think, yes, out is Jinsodor. Montreux record. What is a Montreux record? Montreux record has those places जोटा कि Ramsar sites are considered Ramsar sites but are threatened due to some sort of destruction, some sort of लोक आसी ताकू कमर्शियल एक्टिविटीज करी ताकू लॉस कर देछंती से रामसार साइट रो जो एरियाटा कमी कमी चलची थ्रेटेंड अच्छी. दिस इज मॉन्ट्रुक्स रिकॉर्ड. मॉन्ट्रुक्स रिकॉर्ड रु दीटा साइट इंडिया अच्छे लिस्ट रे. गोटे है लोकतक विच इज इन मणिपुर. गोटे है अगेन केओला देव. दिस इज Rajasthan. Okay, this is Rajasthan, this is Manipur. So all these facts, kindly note them down. टिके रिवाइंड करके आउ थरे देख दियंतु. It will help you consolidate all things in one place. The answer here is Amrit Dharohar scheme. Consider the following statements regarding Supreme Court Legal Services Committee. Okay, ये जो legal services जिनसटा कोर्ट आसुची, legal services जिनसा आसुची DPSP number free legal aid 39A. Okay, just this is 39A, equal justice and free legal aid. तो DPSP even though justiciable no है, but DPSP रे कौन लिखा है? The state shall strive to bring these things into reality. So state has done that in this case, equal justice and free legal aid, and for that they have Legal Services Act, NALSA, Supreme Court Legal Services Committee, all these aspects are related to that. So this is, although this is a DPSP, this is a reality on ground. Okay, so SLSC is a statutory body constituted under Legal Services Authorities Act 1987. This is correct. Okay, and if you ask jodi out ke detail darkar, then actually there was a case called Hussain Ara Khatun. Yes, Hussain Ara Khatun case. जोटे कि सुप्रीम कोर्ट said free legal aid is, of course, it's a DPSP, it's written in the DPSPs, but it's also a fundamental right of people. तो ये सब जिनस गुड़ा ये सब लीगल सर्विसेज एक्ट एंड ऑल हैव बीन ब्रॉट कि लोगों शुड नेवर फील कि मो रिप्रेजेंटेशन नहीं, यू हैव टू प्रोवाइड देम फ्री लीगल सर्विसेज. ये सब लॉयर्स मान को सरकार सैलरी दिए एंड से माने लोगों पाई फ्री रे केस लड़ती. ऑल्दो दिस इज ऑल ऑन पेपर, तांको घूस बहुत दबाक पड़े, अदरवाइज हुए नहीं. ओके, चीफ जस्टिस ऑफ इंडिया सर्व्स एज द पैट्रन इन चीफ. बोथ द स्टेटमेंट्स आर करेक्ट. ओके, statutory body, Legal Services Act 1987. Chief Justice of India is the patron in chief. Other members include the chairman, sitting judge of the Supreme Court, and 9 members nominated by Chief Justice of India. So straightforward, but taro constitutional connect is what I wanted you to learn. Just for your information, 39A जो दुई लेखा है equal justice and free legal aid, सेटा 42nd Amendment Act आस्थिला. Okay, ये जो बार बार अपन जो बताऊँ equal justice and free legal aid, ये जो दुई लेखा है 39A has been inserted by 42nd Amendment Act. This was not originally present in the amendment. So ये सब जिनस आपको ख्याल रखार अच्छे. This is 42nd Amendment Act. Which of the following statements is true regarding dual citizenship in India? Okay, let's see. India allows dual citizenship for citizens living abroad. No. We have something called overseas citizen of India, but they are overseas citizen of India. They are not considered citizens of India. And we also have something called persons of Indian origin, but again they are not citizens of India. India allows dual citizenship only with countries that offer the same in return. No, आम country रे dual citizenship रो concept ही नहीं. Okay, बहुत सारा देश रे अच्छी, but आम country रे नहीं. Akshay Kumar was infamous for taking Canada's citizenship and revoking his Indian citizenship. But I think in recent times he again went back to being an Indian citizen, if memory serves me right. Okay. India offers overseas citizenship as an alternative to dual citizenship. Yes, this is correct. जो जिनसड़ा मु कहली. OCI scheme is applicable to migrants from Pakistan and Bangladesh. No, this is not incorrect. Section 7A of the Citizenship Act. Okay. 7A of the Citizenship Act says कि the parents, the grandparents, the great grandparents of Jadi, if there is someone X whose parents, grandparents, and great grandparents were citizens of Pakistan or Bangladesh, okay, then आमे ताकू OCI status दबोनी, overseas citizen of India status आमे दबोनी, okay. So this is section 7A Citizenship Amendment Act brought in 2005. Consider the following statements regarding ICJ. ICJ is one of the principal organs of the United Nations. It is the only principal organ of the UN which is not located in New York. No Indian. This is wrong. This is right. This is right. This is wrong. Answer is 1 and 2. Let's just quickly go through them. ये जो नो इंडियन अच्छी एबे ही प्रेजेंट जने अच्छंती जस्टिस जे कि 2012 सेठी बसचंती. So this is wrong. English, French and Portuguese नुहे only English and French is correct. And these two only English and French, so this statement is wrong, and these two are correct. Let's just quickly go through the principal judicial organ of the United Nations. Seat is at Peace Palace in the Hague. It is the only one of the 6 principal organs that is not located in the New York City. Okay, 4 Indians have been member of the ICJ so far. Justice Dalveer Bhandari has been serving there since 2012. English and French are the ICJ's official languages. Okay, straightforward. Factual question. Factual. Jodi asuchi tahale hi solve hobo. Jodi asuni eti guess kariyaro kichi logic kichi nahi. Okay. What is the primary objective of Operation Sadbhavna? This is win hearts and minds of people in Ladakh through civic action. ये जो ऑपरेशन सिंदूर हेगला एबे गोटे ऑपरेशन सिंधु चलची इरान रु आम नेशनल्स को आनिया पई केबे आई थिंक लेबनन रु आनथिलो आमे केबे गोटे तार को गोटे ऑपरेशन थिला एमती यूक्रेन रु आनथिलो गंगा आई थिंक ऑपरेशन गंगा तार और ऑपरेशन गंगोत्री समथिंग लाइक दैट तार गोटे कौन थिला तो ऑल दीज एस्पेक्ट्स यू हैव टू बी केयरफुल अबाउट ये सब रिसेंटली जहाँ जहाँ न्यूज़ रे रहउची तो तार टिके करंट अफेयर्स बेस्ड नोट्स आपण बनेबे एमती गोटे गोटे सिंगल लाइन रो फैक्चुअल क्वेश्चंस आर पॉसिबल. Operation Sadbhavna is a unique human initiative undertaken by Indian Army in Ladakh to address aspirations of people affected by terrorism, sponsored and abetted by Pakistan. Okay. So seti semane government schools, infrastructure development, education tours, all these aspects they will be taking care of. Okay. Factual question. Odisha government recently signed a MOU with National Dairy Development Board to set up a new facility to produce anthrax vaccines. Which of the following best describes a real world concern associated with anthrax? Okay. Concern being it mutates rapidly, complicating vaccine development. No. Vaccines are available for anthrax. एमती किसी complication नहीं. Mutate भी हुए नहीं as such. Okay. So this is wrong. Spreads widely through contaminated drinking water. Again wrong. This is only from one animal infected animal to another. Okay, contaminated water हुए नहीं. It can form spores that survive in soil for decades, posing bioterrorism risks. This is the correct option. It causes seasonal flu-like symptoms and resolves without treatment. No, it is actually highly fatal. And थरे हेगले ताको ये करिवा बहुत कष्ट. Okay. ट्रिटमेंट दरकार एंड से भी फेटालिटी रेट इज रियली हाई. ये जो जिनसटा बायोटेररिज्म जिनसटा टिके आपण जदि पढ़ी देबे इट विल गिव यू अ गुड आइडिया. Anthrax is caused by bacterium Bacillus anthracis. Okay, they can survive in soil for decades and are difficult to eradicate, making them a significant concern in both natural outbreaks and deliberate use as a biological weapon. 2001 anthrax attacks in the US highlights as its use as a bioterrorism agent. And these are the remaining 3 statements that are incorrect. Okay. Which of the following best describes the term global south? एमती पाखापाखी मीनिंग रो 4टा खंडे क्वेश्चन थिबो आपनको आइडेंटिफाई करियार अछि which is the best meaning. Okay. geographical grouping of countries located below the country. No, this is the most obvious strong one. Jadi एटा ठीक है थांदा, then एटा के भी question ही न थांदा. Okay, it has nothing to do with geographical or the equator or any latitude. Okay, let's see. Group of developing nations in Asia, Africa and Latin America with shared social economical challenges. Yes, this is the right one. Southern hemisphere, no. Tropical countries affected by climate change, no. आंको समस्तଙ୍କର ଅଲଗା groupings ଅଛି, but global south is basically this. Okay, ଆଗରୁ ଗୋଟେ derogatory term ଥିଲା called third world country. Okay, ମାନେ any जो African nations ହେଇଗଲେ and even India to a large extent in its early years, we were all being termed as third world countries. So since it was negative in connotation and derogatory थोड़ा सा, तो ताकू ये करिया ପାଇଁ they termed it global south. Okay, so global south, some history of colonialism. Okay, debt ridden, बहुत सारा तांकर debt थिबो, inequalities थिबो society रे. Okay, economic issues थिबो, employment न थिबो, poverty थिबो. Okay, and all those socio-economic indicators, माने health ହେଇଗଲା, education ହେଇଗଲା, सब poor socio-economic indicators. तो ये सबू countries को मिसेकी they have termed it the global south, and India is actually trying to become the voice of the global south. So India conducted the voice of global south summit 2 times in 2023. Slightly outdated, but they can ask in some context. So ये सब जिन सब टिके ख्याल रखिए. Again, very very factual. खंजर, शक्ति, nomadic elephant, वज्रपहार, युद्ध अभ्यास. Okay, dust lick, सिम्बेक्स, मैंने some top of धर्मा, गार्डियन, ये सब आमर आर्मी एक्सरसाइजेस विथ डिफरेंट कंट्रीज. एमती गोटे लिस्ट बाहर इवेंचुअली ऑफ 25 to 30 एक्सरसाइजेस. से माने बहुत ज़्यादा पचारते या विषय आहरी डिटेल रे भी पचारते केबे फर्स्ट हेथिला, कोठी लास्ट हेथिला, कोठी कौन हेथिला, थीम कौन थिला, एयरफोर्स इन्वॉल्व थिला या नेवी इन्वॉल्व थिला. तो टिके डिटेल रे ये सब एस्पेक्ट्स देखिए बिकॉज दिस इज हाईली रेलिवेंट टू वेयर ओपीएससी फ्रेम्स क्वेश्चन फ्रॉम. ओके, so Khanjar is Kyrgyzstan, India and Kyrgyzstan. Shakti is India and France. Nomadic elephant is India and Mongolia. Vajra Prahar is Indo-US. Okay, so tikke just a sub jin sab you have to be careful. Great Indian bustard. Okay, there's a bird found mainly in Rajasthan and Gujarat, has been categorized as vulnerable by IUCN. So it is our photo achi. It is, yes, it is found mainly in Rajasthan and Gujarat, but it is actually critically endangered. Okay, ମୁଁ ଏଇ କ୍ୱେଶ୍ଚନଟା ଆକ୍ଚୁଆଲି ଟେଲିଗ୍ରାମ ଚ୍ୟାନେଲରେ ଅପଲୋଡ଼ କରିଥିଲି, ଆଣ୍ଡ ଆଇ ଥିଙ୍କ 20 days later ଏଇ ଯେଉଁ ୟୁପିଏସ୍ସିର ଯେଉଁ ଗୋଟେ ଏକ୍ଜାମ୍ ହୁଏ CDS କମ୍ବାଇନ୍ଡ ଡିଫେନ୍ସ ସର୍ଭିସେସ୍, ସେଥିରେ ଆକ୍ଚୁଆଲି ଦେयर ୱାଜ୍ ଅ କ୍ୱେଶ୍ଚନ୍ ଅନ୍ ଦିସ୍ ଯେଉଁଟାକି ଏଇଠୁ ସଲ୍ଭ ହେଉଥିଲା. Which of the following is found in arid and semi-arid regions? Sethre the option was Great Indian bustard. So jane pila mate actually text kartile ki sir mu apno telegram channel ro student, and ei question das 8 solve kartili boli exam hall re it helped me. Not that mane mu credit noni, but yeah, this is what mane mu eta dekhiya chesta korchu je all these questions are very relevant for you. So if you want to join this test series, then please feel free to join it. Okay, the questions emti bhi kichi mane yadu sadu frame hi nahi. So the answer is one only. Which of the following statements best describe the NSDC? It is a constitutional body. No. NSDC is National Skill Development Corporation. NSDC is a government agency. No. It is a public private partnership established to promote skill development initiatives. Yes, nothing much to talk about here, it's just what it is. Okay, in the context of artificial intelligence, what does the term sovereign AI refer to? Same thing, global south bhaliya एटी भी चार्टा options, चार्टा confusing options दिया हवा. It can mean anything, but you have to say what is the right one. Okay, denotes AI systems developed and controlled by private corporations, refers to AI technologies that operate autonomously without human intervention, represents AI applications that prioritize individual privacy, ensuring user sovereignty. It denotes AI systems developed and controlled by government or state entities. तो एठी आमे सीधा सीधा ई sovereignty वाला aspect ऊपर direct jump मारिबा. इंडिया इज अ सॉवरेन डेमोक्रेटिक रिपब्लिक नेशन वाला सॉवरेंटी कि हाँ हमारी मर्जी जो है हम वो करेंगे एज अ नेशन वी हैव दैट राइट. सो सॉवरेन एआई डिनोट्स एआई सिस्टम्स डेवलप्ड एंड कंट्रोल्ड बाय द गवर्नमेंट और स्टेट एंटिटीज with a focus on national security and strategic interests. This is the answer. This is Ministry of Earth Surfaces. Ministry of Earth Sciences. Sorry, Ministry of Earth Sciences. ସେମାନେ ସବୁ କେତେଟା ଜିନିଷ ଡେଭଲପ୍ କରିଛନ୍ତି ଏଇ ଯେଉଁ ପୃଥିବୀ ବିଜ୍ଞାନ ସ୍କିମ୍ ଅଣ୍ଡରରେ. ଓକେ, ପୃଥିବୀ ବିଜ୍ଞାନ ସ୍କିମ୍ promoting research in earth systems, science, technology and human resource development. Ministry of Earth Sciences, this is the tenure, this is the budget. Objective is to address all aspects of earth system sciences and provide reliable services for societal, environmental and economic benefits. अब ये जो सब जिनसे ମୁଁ ପଚାରିଛି ଓ ସ୍ମାର୍ଟ, ପେସର, ସେଜ୍, ଆକ୍ରସ୍ ଆର୍ ରିଲେଟେଡ୍ ଟୁ ୱାଟ୍. ଓକେ, ସୋ ତା ସବୁ କ'ଣ କ'ଣ ଫୁଲ୍ ଫର୍ମ ଅଛି ଆପଣଙ୍କୁ बस ଯଦି ଆଇଡ଼ିଆ ବି ରହିଯାଉଛି ତ ୟୁ ୱିଲ୍ ବି ଏବଲ୍ ଟୁ ସଲ୍ଭ ଦିସ୍ କ୍ୱେଶ୍ଚନ୍. ଓକେ, so if you want to read it you can just pause it, not going to waste my time. Bas simple facts that waste my or your time, basically simple facts that you should know. Okay, NATO. Which of the following statements about NATO is correct? NATO was established primarily to promote economic cooperation. Wrong. NATO is a military alliance founded to provide collective defense and security against external threats to its member states. Right. NATO's headquarters is located in Brussels, Belgium. Correct. And it operates under the direct control of the UN. Wrong. It is independent of the UN. NATO membership is limited to countries in the European Union, excluding non-EU members. Again, wrong. Turkey is a member of NATO. It is a non-EU member. Iceland is a member of NATO. Norway is a member of NATO. Macedonia, North Macedonia is a member of nation. And all these are non-EU members. So this statement is also wrong. You should also know that there are some partners of NATO. There are some members. Okay, members to hegale core, but there are some non-member partners. Sethre asjauchanti amar countries like Japan, South Korea, Australia and New Zealand. Okay, so they are strategic partners of NATO, but they are not members of NATO. NATO re e sabu non-EU members plus EU members achandi, and this is NATO ଯାଇକି ୟୁକ୍ରେନ୍କୁ କହିଲା ଆମକୁ ଜଏନ୍ କର, ୟୁକ୍ରେନ୍ ଜଏନ୍ କଲା ବୋଲି ହିଁ ରଷିଆ ତା ଉପରେ ଆଟାକ୍ କଲା. Russia had no choice. Okay, and it is not an economic cooperation. So this is what NATO is about. That easy, very easy. So that brings me to the end of this question paper discussion. If you like that quality of discussion, then feel free or consider joining our test series. Give us a call. The number is in the description. For any other queries, just DM us on WhatsApp and we'll get back to you within 5 to 10 minutes. We are very famous in our circles for being very responsive to queries and doubts. Until next video, I'll take your leave. Namaskar and thank you.